Yes, pardon to mention, my lord, the fresh admission.
Give your slips.
Item number 37.
Give your slips. Mention the urgency.
My lord, item.
Mention the urgency.
Similar matter, my lord.
This is my request to the members of the bar, that for urgent mentioning, you are not required to go to the Deputy Registrar Judicial. Whether a matter is urgent or not, he cannot decide. That urgency can be decided by the court only. So yesterday I have instructed not to entertain any such slip. So urgency, we are here to decide. Respective benches shall decide the urgency, not the registrar. We will see. Just you have mentioned the urgency in your slip.
Yes, ma'am.
We will see.
Item 37 on your lordship board.
Yes.
This matter was fixed by your lordship for hearing at 2 p.m. on the 5th of August. On the 5th of August, your lordships were pleased to make an order directing the state government to file a counter subject to payment of certain costs. Now, counter has not been served on me. I do not know whether the other part of the order has been complied or not. The matter was fixed to today. So may I pray this matter be taken up at 2 p.m. today?
Just come at 2 p.m. Who is for the other side?
The state government. Item 37.
In fact, what we would suggest that
Yes.
come at 3:30.
Yes, sir.
If by that time your matter is not taken up, we will take up if the matter is so urgent.
Obliged.
Item 30, item 30, that is a contempt matter. Petitioner is not getting pension. Even after dismissal of the SLP, the pension has not yet been released and returned. On 11/7, my senior taken time to file the compliance affidavit. Not yet filed. Maybe taken up at
Item 40.
Item 40.
Who is appearing?
My
Item 40, I think affidavit has been filed. I will also find out. I think I have filed the compliance affidavit now.
lordship may take up to 2 p.m.
I will take up your matter today.
There are two contempts only, lords. Your lordship can take it up both the contempt at 2 o'clock, lords, can be disposed of.
Pardon, my lord, similar matter, item number 4. Now,
What is similar?
academic matter, disaligning admission of the student for the academic test.
Item number 4 of what?
Similar matter, my name, mention myself.
Give your slips, all of you.
Item number 38, madam.
Please give your slips.
Item number.
Permit to mention your lordship, kindly permission to mention a single bench matter assigned to your lordships.
Single, all right?
Here is a urgency that we nominated our arbitrator Justice B.N. Ratha, former judge of the.
No, but how can you make a mention before DB? A matter which is.
Taken to the urgency.
Item number 38, my lord. In item number 38, first case, my lord, I am permitted to withdraw. First case, my lord.
Most welcome.
My lord, item number 26 permitted to withdraw.
Lordship, one interim application arising out of Martha number 346 of 2023.
Give your
Earlier disposed of by Honorable Justice B.R. Sadak and Honorable Justice M.S. Rao. Lordship, I have kindly be directed for listing of the matter before Honorable.
It will be listed automatically.
Batch of writ petitions, your lordship, regarding the motor vehicle act, your lordship will take hard July. That is pending, but it's for
All right.
My lord, pleadings have already been over for listing for hearing, my lords.
Motor vehicle consent.
It's a 2020 match.
Additional.
My lord, pleadings has been already over for listing of matter, 2020 matter, your lordships. It is 2020 matter, my lords, for listing of the matter of pleadings has already been over, my lords.
For the first time.
My lords.
Give your.
Complete, sir.
Grateful.
This is a fresh matter, my lord. It's a minor mineral matter, my lord. For first time listing, my lord. I came before your lordships in the first round, my lord. Your lordship set aside the impugned order and sent it back to the government for reconsideration. Now the government has paraphrased the same order and has passed the same order. My lord, challenging the same, I am before your lordship. Any day subject to your lordship. My lord, I am deeply obliged.
3.
Supplementary list item number 3.
May I, my lord, the secretary is present here. Before he, my lord, answers the queries of this honorable court, yesterday I have found out the papers. And what I could find out, my lord, in order to make it more simplified, what has happened is 171 posts were advertised. Also, if I kindly mark, my lord. And my lord, a list of 171 was recommended. Thereafter, on 11/1/2019, government wrote a letter saying that 5 persons, dental surgeons have not joined. You send us, you are category 4 and SC1. They did not write to them that which are the roll numbers which have not joined. They only wrote a letter stating therein that 4 UR candidates have not joined, 1 SC candidate has not joined. So therefore 5 have not joined. So you send us another 5 names.
There is a factual error.
My law and
Just
allow me.
let him say.
171 we had recommended. Now government said 5 have not joined. So we had recommended another 5.
So that recommendation was when?
That recommendation was by the Public Service Commission on 17/3/2019. While preparing, my lord, this
Just one. If it is 17/3/2019, how can the government write a letter on 11/1/2019?
government first wrote a letter, my lord, 11th January 2019.
But you have sent the list on 17/3.
We sent another 5
names.
Another 5 members list.
Oh, I was asking for the first one, not the next 5.
The first one,
Yes.
they were all appointed as dental surgeon on 18/8/2018.
All right.
171.
Yes. That date I wanted.
Well, I'm sorry, my lord.
No problem.
Now, since these 5 recommended candidates, their marks were to be revised, and it got revised also, but it could not be brought to the notice of the honorable, my lord, to the state government. That's out of the 5 in the revised cut-up, they will not come. Only 3 will be. 3 will not be there.
So you revised the marks of only 5 candidates or all the 177?
No, 171, my lord, we revised. These 5 whose marks were being revised, my lord. Now that list could not be sent to the government. We have now, my lord, recommended only 8 people will be out of this, not 8. 8 plus 3, 11 will not be there.
All right.
I hope I am being able to, my lord.
Yes, 11 will not be there from amongst those
And I have
who were
spoken to
earlier.
the commission, my lord, yesterday, that these 3 who are not coming within the cut-up marks, in the revised cut-ups, the OPSC will also, my lord, recommend to the government that these 3 will not be there. Another 3 will be there from the list.
All
Revised.
right. Again, we are putting a very simple question. There are 171 persons working or not? Or 166?
171 we recommended, 166, my lord, joined, 5 did not join.
So 161 are working.
165.
166 are working.
166 were working.
So how many persons are working?
So 166 and thereafter 5, sir.
171 are working. All right. 171 are working. Now, what is the breakup? You are?
Sir, you are 121, sir.
You are 121.
Sir.
And?
Sir, you are 121. 29 is SC and ST 21.
All right. Now tell us, from amongst those who are working, who has the minimum marks,
sir,
in UR category according to the revised merit?
Sir, 184.934 as per the revised marks.
184.934.
934.
SC?
No, sir, that is
You
yours,
are right.
in your category.
What about SC?
SC category, the last candidate, sir. One 24.588.
124.588.
588, sir.
And ST?
ST sir remains the same, 120.740 for male candidates, ST male, and 125.027.
120.740
740
for
ST male,
and 120.
120.740 for ST male,
Ah.
and 125.027 for female, ST female.
027.
Yes, sir.
All right. So there are persons above 84.934
Sir.
who have not been recommended.
Yes. Yes, ma'am.
So what is the revised marks of these two?
They will not come. That yesterday we checked it off, my lord. They are not coming within the cutoffs. That's okay.
Just a minute. What is the marks?
What of the-
The candidates, sir.
Cutoff? No, their marks.
what of the-
That revised, sir, cutoff, sir, is. Revised cutoff is, you are male 192.558, female is 192.
No cutoff. What is
They
the
are not-
marks obtained by one of the applicants or both the applicants?
Appellant.
price.
Please, let us be clear. We will come to you.
The 500, right? 500. There must be a note there. Please give that. Loose paper in that file. Please see if there's any loose paper in that file. With admit or notes out there. On this.
Sir, revised marks of the candidate, one Dr. Sanjay Panda, so 191.210, and sir, Dr. Anil Kumar Sahu, 192.002.
191.210.
sir.
Whose
And
number?
of Dr. Anil Sahu, sir, 192.002, sir.
And 192.
002.
Doctor?
Anil Kumar Sahu.
There are two persons. One is 191.210.
Sir.
This is whose marks?
Sanjay Kumar.
Dr. Sanjay Kumar Panda.
So this is their revised score.
Yes, sir.
So, but according to you, the persons with 184.934 are working.
Sir.
So admittedly, these two persons are more meritorious.
Yes. Yes.
You're saying 8 persons are working who have not got above the revised marks.
Sir.
8 plus 3.
8
11.
plus 3. 8 we have already, 8, sir, madam. In the
Just one moment. But 3 is,
3 is that those 5 people, those who are being recommended thereafter.
no, but why 3 and not 5?
No, sir, two are above the cutoff, sir. 2 are above the cutoff. Out of the 5, 2 are already above the cutoff.
All right.
So in any view of the matter, these persons have been recommended and they are working with marks 184.934.
Sir.
And those above them are not working because their names have not been recommended. So whether this is violative of Article 14 or not?
Actually, sir, they were recommended previously, sir. Not as per the revised marks, sir. They were recommended previously, sir, in the pre-revised marks.
Why are you, why this, all right, pre-revised marks, they were recommended, wrongly recommended.
Yes, sir. Wrongly means that time they were coming under this, sir, within the, sir, in the pre-revised scale, they were above the cutoff, sir.
Wrongly recommended because you revised the result. All right. It is not that someone else revised the result.
Sir.
You revised the result, you found that this should be the revised marks, and
Yes.
accordingly, so therefore they were wrongly recommended. So they have a clear case. So what do you propose to do now? Are above 84 who have not been recommended?
Sir, 43, sir.
43.
Sir.
The gross breach.
This 11 will go and the 11 will come. Then also the petitioner case, they are not coming within the cutoffs.
More above the-
No, you have created.
I completely bowed on my
You
lord.
recommended the government not
Completely
to.
bowed on my lord. What propositions, what will also be saying, my lord?
You recommended to the government that since they are working,
And you could not do that. Yes, anything else?
One thing. The secretary is present and his counsel making statement. Statements are absolutely wrong,
What?
based on record. If your lordship may verify, my learned friend submitted for 175 posts, there was an advertisement. Your lordship have recorded that.
Not 171, will recommend it. I have
How
never
many
said
posts advertised?
190 per day.
190.
It is 198 posts which has been advertised.
Yes.
I have prepared a list of your candidates. Yesterday I have submitted to your lordship. In that list, 126 reserved for UR. 126 seat reserved for UR. If your lordship will see the chart yesterday I have submitted, they have submitted the name of 119 candidates above us, above Dr. Sahu, and have been appointed. And 120 candidates above Dr. Ponda. I have shown in the list. If there is 126 seats, our serial number is 120 and 121. As per their name recommended. And the other thing is, my lord, in the first writ petition, when they did not supply the expert committee report, I approved this honorable court. This honorable court specifically directed that 6 candidates made a representation being agreed by the wrong key answer.
No, but you will have
Three-
to, Mr. You will have to implead them as parties.
No, let me see. All of them were parties.
Huh?
My lord, all of them were
all those 46 persons
no,
were above you.
46, not 46, my lord.
No,
This honorable court
whether the-
directed,
Just whether the persons
my lord.
whose score is less than you, they
Now they are disclosing before your lordship. Now in this writ appeal they are disclosing. Therefore, they did not disclose before the honorable single judge. The honorable single judge categorically asked them 2 names. They suggested that 2 candidates securing less mark, they have been selected. The honorable single judge, upon verification of the document, could found that 2 candidates. Thereafter, the honorable single judge asked them, if the candidate who has secured 190, he could be given appointment. Why not 191, 192? And they have no reply in this writ appeal also. They have not taken any ground that such a question was not put by the learned single judge.
Question was not put.
Prior to that, I am submitting, my lord, the honorable, there was 2 single judge judgment. First honorable single judge directed the OPSC, whoever made a representation to you, their answer script may be re-evaluated, taking into consideration the expert committee report. And they have evaluated 6 candidates. On 17 to 2022, the OPSC informed us that since the Honorable High Court had directed to evaluate the answer script of the similarly situated candidates, we have examined 6 candidates and it is found there is no change in the mark. That means whatever mark we have secured earlier, that remain intact. That is at page 95, 96 of the present brief, Your Lordship. Despite the order, thereafter,
This was before the revision of marks or after?
after revision of the mark, they submitted. Your Lordship, may kindly have a glance to page 9. Kindly have a glance. 95, 96. Page 94, 95, 96. That was challenged before the Honorable Single Judge. The letter dated 17/2/2022 issued by the secretary. Whereas after batch of cases bearing number so and so, 6 writ petition has been mentioned, had been filed by 6 candidates, namely Suman Tripathi, so and so, so and so. And the matter was taken up by the Honorable High Court, where the Honorable High Court on 15/11/2021, 26/11/21 disposed of the same, observing that accordingly it is directed that the commission shall open the report of the expert committee and consider the candidature of the petitioner along with the similarly situated candidates in terms of the said report submitted by the expert committee and communicate the result thereof to the petitioner within a period of 2 months. Hence, if the petitioner as well as other candidates who had made a representation to the commission being dissatisfied with the evaluation of their answer script are found suitable for the appointment, necessary recommendations shall be made to the government for their appointment. In pursuant to the order dated 15/11/2021 and 26/11/21 passed by the Honorable High Court in WPC number so and so, a batch of cases, this commission has considered the case of the applicant by scrutinizing, Your Lordship, scrutinizing the answer book again by taking into report of the expert committee. It is found that cut-off mark finally selected UR candidate M category 189 and cut-off mark finally selected candidate URF 188. In view of the above mentioned fact and circumstances of the case, this commission has decided, since the above mentioned 6 candidates have secured less mark than the cut-off mark, and for their names for recommendation for the post of dental surgeon junior pursuant to the advertisement number 17/18 cannot be made. After taking into consideration to the revised mark, my lord, the secretary, the present secretary, wrote a letter to us that there is no change of mark. Now he is saying that after revision,
Why are you saying this present secretary or past secretary? Secretary is secretary.
Secretary, my lord, sorry, ma'am. The secretary intimated there is no change after the examination of the answer
Where
script.
is that? There is no sentence like that. There is no change.
Your Lordship, page 96.
Yes.
In view of the above mentioned fact and circumstances of this case, this commission has decided, since the above mentioned 600 have secured less mark than the cut-off mark. Cut-off mark has been mentioned, 189.558. Above sentence, my lord.
Mr.
He mentioned
The concept of cut-off marks has been confused. Cut-off marks, the cut-off marks pre-revised and post-revised. So they had to decide what ought to have been cut-off marks pre-revised and cut-off marks post-revised based on the number of vacancies advertised.
Right.
So this was an exercise which they were required to undertake.
After conducting the exercise, after the first order passed by this honorable court, they held that the cut-off mark is 189.558 and we have secured, even after the expert committee report, we secured a less mark than 189.885. This is the letter under Annexure 4 at page 95. Relevant portion is at 96. And thereafter, I filed a contempt petition before this honorable court. Without examining the expert committee report, they have superfluously has passed an order by saying there is no change of the mark. The expert committee report may kindly be supplied to us. They did not supply the expert committee report, however, they submitted the same before the honorable single judge. Thereafter, after the first contempt, again they have, their lordship, your lordship may kindly have a glance to page 108. 108 of the brief. Same secretary again.
All right, please wait. Do you have the merit list pre-revised?
Yes, sir.
Give us.
Brown file again. Brown file.
Yesterday, it's okay. Yesterday, the small black paper. That's in serial number 2, my lord. Serial number 2.
No, but no page mark, so we'll look for
We have not done the page mark.
it.
It is being written, recruitment to the post of so and so, 171 candidates before revision of the answer.
Yes.
Lots of
Please,
questions.
yes, got it. So these were the 171 who were recommended,
Yes, sir.
and you have marked in red the persons who did not qualify subsequently, but are working.
But are working.
What happened to the roll numbers 10415
We have found it out.
male
We have found it out. madam.
and 101895 female? What happened to that?
They have been recommended, ma'am. The 5, which has been letter, which has been recommended as per the government letter, in that they have been recommended 101415. Lokanath Solanki.
Could
She has
not
been
have, could not have been.
She could not.
Mark the
Therefore, what I said, my lord, at the outset, that another
Oh.
3 will be now there.
Another 3 will be.
So 8 plus 3, 11 will be there, man. Now,
So after this 171, 5 names had been sent.
well, yes,
So
sir.
their names are not in this pre-revised
This-
list.
Yes.
So what are the roll numbers which you had sent? Oh, you are saying 3 have
Lordship,
qualified.
I have this copy. The lordship may kindly go through it. I have also marked it. This also, another copy is also.
This, if you would have given it yesterday, would have been clear. We have been
My
looking.
lord, I'm sorry, my lord. Yesterday, while going through all the papers, we could be able to, my lord, find out. Oh, sorry for creating that.
Please come to this comparative pre-revised and revised marks of 171 recommended candidates. Which you are candidate scored 184.934
Yes.
revised. Which candidate?
So that is not there, sir. So pre-revised and revised marks of 171 only, that has been taken in consideration in the pre-revised first 171 and later revised view. We don't have the idea which 5 candidates have not joined, sir. So we have prepared a 171. That is
No, you have given us revised and pre-revised.
yes,
So these are 171 candidates who were recommended.
yes.
According to you, one person having 184.934 revised
Yes,
is working.
yes.
Who is that person? His name must have been recommended in the first list.
Oh, sir, that is in the second page, sir. The first page, that name was not there, sir. 171.
Within 5, now next 5.
In the next 5, sir. That I have given, sir.
Where?
Now they give.
One. Sir, in the at the serial number 4, sir. 101250. Debasis sound.
When did you make the recommendation?
It's 5.
5?
When?
Year 2019, sir.
After revision?
No,
No,
sir, that is before revision.
Before revision?
Yes, sir. Revision has been done in the year 2022.
Only government can say out of those 171, which 5 had not joined.
Yes, sir.
May kindly see the government letter which I have given also.
Can you give us the list of those candidates who are above 184.934?
Yes, sir, that is there. 184, sir, that is there in the last page of the which I have given.
But yesterday or
Sorry,
today?
recently, which
Today.
I have given.
Today.
43 candidates. Today, sir, I have given.
Yes.
Where?
Last week. Another one? Yes. And Dr. Ponda and Dr. Sahu has that serial where? I
Have
think
you given?
six.
Sir, yes.
6. This doesn't match.
1 G.
What is your roll number?
My roll number is 101074, serial number 3 of that list.
Oh, just a minute. 10.
1074. As against serial number 3.
6.
And another is 101716, serial number 6.
Any advertisement was issued?
After this, during the course of hearing before the Honorable Single Judge, one advertisement was published. Then we made an application during the pending 17 seats from this advertisement are being taken to other advertisement. Therefore, since our case is pending, 2 posts may be kept reserved. And the Honorable Single Judge passed an order that 2 posts in the said advertisement shall remain vacant for the petitioners of by mentioning these names. And accordingly, the secretary has also passed an order to that effect that out of the total advertisement, 2 posts shall remain vacant in respect of OJS number so and so so and so.
Second advertisement, how many posts did you advise?
That is 192 posts.
192 posts in the second advertisement,
Yes, ma'am. That is third advertisement.
whatever.
Yeah, that is.
Third means?
No, means in between there is one another advertisement, one recruitment has been done. It is, that is advertisement of 2/23-24. In that case, in that advertisement, 2 posts have been kept vacant as per the order of.
What about the other posts? Any vacant posts left?
Only 2 posts have been kept.
You have kept vacant as per the order of the court, but otherwise everybody else has joined.
Yes, joining, we have not the knowledge about the joining, but we have recommended, except the 2 we have recommended also. You are candidates, all recommended, all you are.
Sir, vacant, can you
That is what government will say.
Posts have been kept.
forget
Yes.
to
Government can say.
posts not advertised?
I'll have to find out because
This is a
the
letter.
state had not filed any counter affidavit in this case before the Honorable Single Judge. So facts are not, I'll try to.
No, not about this. This, they have said 171, 5 did not join, you asked for 5 and this is
Yes.
a total mess.
My lord.
Second, third advertisement, after that are any posts?
2 posts will be there, my lord.
2 posts are there.
2 posts we are not asking. We are thinking of the plight of those persons who have joined and those who have not joined.
These
So far as my
they-
knowledge
they-
goes, the entire advertisement was made by this second advertisement. About 40 to 50 posts has not been recommended, for which some students have filed a writ application, that is WPC number 41265 of 2023
Pending,
before this honorable court,
pending.
pending. And the secretary has filed a counter affidavit there. How many posts has been filled up, how many left vacant?
That are-
Now the secretary is saying all the posts has been
Please don't-
recommended.
Please let me
Don't
tell.
make such
Please let me
statements.
tell.
We are trying to.
In the
find
UR
out
category, there is no vacancy, ma'am. ST candidates, there is no ST candidates, available eligible ST candidates, so STD post remains vacant.
He has everything at the tip of his fingers, but he's not mentioning.
And this one page, your lordship may kindly have a glance. This is the counter affidavit file. One page where it has been mentioned 2 posts has been kept reserved. This is the
Reserved including. Reserved including.
no infirmity in the judgment of the honorable single judge. They have not challenged the fact.
Mr. Counsel, there is infirmity not in the judgment of the court, but in your stand. You could have impleaded them as parties. You did not.
But if the
Then where is the,
OPSC
see,
OPSC would have,
Mr. 2 seats were kept reserved for you.
Right.
In the subsequent advertisement.
Right.
How could you be appointed against the advertisement against which you had not applied? You had not applied pursuant to this advertisement.
no. Because the first advertisement 198 posts. Out of 198 posts, they filled up only 171. They could not fill up other posts. Your category that were 126. We are coming within 126.
By two
Your right is confined to whatever, 192 or whatever posts which were advertised,
Yes.
not beyond that.
No,
Yes. So
I am not claiming, my lord. Out of 126,
you are not claiming.
your vacancies, they filled up only 119. If they will fill up another 7, then I am coming within the zone. They did not fill up 198 vote. Had they fill up 198 vote, then I would have got that.
We will see. File an affidavit bringing these documents and these facts. This matter on Tuesday. Secretary employee is present. This matter on Tuesday. So,
Can I pray? Wednesday.
Wednesday.
What?
Also, on the next date, an affidavit shall be required to be filed sworn by the Secretary, Odisha Public Service Commission, giving the furnishing following informations, colon as merit list based on re-revised marks to recommendation made by the OPSC, category wise, based on pre-revised select list. Top next, copy of the commission of the minutes of meeting of the OPSC dated 25/7/2022, whereby the revised merit list was accepted. You had accepted the revised merit list.
The revised merit list was accepted in the year, in the November 2000. Just
411. This one.
411. When we have a recommends.
25 copy of this. What had happened on 25/7/2022, whereby the commission had accepted a revision in the key answers.
Yes.
Copy of the next copy of the cutoff marks fixed, bracketed, pre-revised and post-revised. Next, copy of the revised select list. Copy of the revised select list. 5 million copy of the primary cutoff marks, revise and post-revise. List of eight newly selected candidates with their respective marks pre-revised and post-revised. Next, copy of the recommendation of 8 new candidates after revision. Pre-revised and revised marks of the recommended candidates. copy of the letter dated 11/1/2019, which has been brought to our notice. Copies of the letters dated 11/1/2019 and 7/3/2019, which have been produced before us by the Secretary OPSC during the course of hearing of the case. Along with the list of 5 recommended candidates due to non-joining of earlier candidates. Non-joining of some of the candidates earlier recommended.
Not qualified in the second, but working. Not recommended, but they are working. So the 11 candidates are not recommended in the second list, but working.
No, you did not make any recommendation after revision.
They waited.
After revision, they sent only for 8 persons.
See,
8
revision for you was meaningless. Revision for you was meaningless. All right, you did not act upon. You accepted the revision, you prepared the revised merit list, but for you revision was meaningless because you did not do anything. You just made a recommendation that let them continue.
If they make a representation, government will consider.
Next. List of candidates who secured more marks than the last recommended candidate as per the revised secured more marks post revision than the candidate who is than the last candidate who is presently working.
11 candidates, if you get the names also, they will not qualified without.
List of candidates who ought not to have qualified, who ought not to have been recommended with the recommended because of the revision in marks, but are working because of their earlier recommendation. The affidavit must be filed by Wednesday.
One more fact. The list of candidates who did not join. The list of candidates who did not join.
We'll find it out.
Unless that, then the entire list will be recast.
Next, let an affidavit be filed on behalf of the estate, giving the details of the candidates who had not joined and were recommended by the OPSC for appointment as dental surgeons,
Dental.
as dental.
Recommended, but they not take.
Didn't join.
We ask,
Nothing, it's a peculiar situation. A peculiar situation, so you will have to. There's so many things the Supreme Court says that you cannot.
Okay, you cannot take from those lists, but every year they are having Yes.
No, it is the information which we are seeking. Is the kind of order which we shall be passing on the basis of these admitted facts. The nature of order. And you will have to examine the Supreme Court's decisions also.
I have brought 3 judgments. I will apprise you, Lordship.
These judgments, the judgments should not be only in your favor.
No.
There are judgments.
Yes, taking into consideration
Yes.
this type of scenario.
Yes,
what
so
should
we
be the
cannot,
approach of
we cannot ignore cases of such candidates
Yes.
who are not there before us.
Yes. That in some of the cases, their interest has been protected.
You see,
I will bring those up.
Wednesday, first 5 cases.
Item number 1.
Can I pray this matter to taken up next Thursday? I have not made the homework your Lordship directed to.
Thursday, all right?
Just to remind your Lordship that court of what's matter.
Yes.
Yeah.
This is asking for
Item 1.
wanted some homework, you want some time. Item 1. Request from one.
As requested, what is this? Next Thursday. Right. Why doesn't
That OPSC Wednesday, this on Thursday.
Item number 2.
Item number 2, my lord.
Affidavit are directed by your lordships and shall be copy on my third pen.
My lord, I am appearing. My lord, I am appearing in VC in item 2. My lord, just now my associate received the affidavit filed by my learned senior as per your lordship's direction on the last occasion. What I pray, my lord, I will go through the affidavit, and I am actually suffering from fever, dengue. I am on accommodation. So your lordship may give me 7 days time, 7-8 days time, so that I will go through the affidavit and the matter can be decided, your lordship.
So you are representing whom?
Representing the petitioner, your lordship.
Learned counsel for the petitioner states that he has received a copy of the counter affidavit or additional? An additional affidavit today itself. First off, he needs time to consider the said affidavit and file rejoinder, file reply if so required. First off, as requested, list this matter on next Thursday.
My lord, little more time may be given because I am suffering from fever.
2 weeks.
Oh, lordship. Oh, lordship. Oh, blessed.
Item number 4.
Lordships, we have received the counter in that ITI matter. If I be permitted to place the facts serially, then your Lordships will be able to understand that how the counter is absolutely misplaced. Your Lordships will just take what first happens is your Lordships is annexure 2, page 15.
Annexure
2, page 15. 1-5.
counter affidavit.
That's when they take a decision.
No, counter affidavit is not there.
Counter affidavit is
We filed it yesterday, your lordship.
It was stated by learned counsel. An AGA representing the estate that counter affidavit has been filed. Full stop. Said counter affidavit is not there on record. File on,
Yesterday, your lordship. Yesterday, your lordship.
file on. Calcutta. Said counter affidavit is not there on record. So does this matter on?
You know, so this is an urgent matter because the last date is 31st.
Huh?
Last admission.
Before
It
that.
can come tomorrow.
Tomorrow it will not come.
On
It will
Tuesday,
come
your
on. Where is-
You know, so that's September.
on
Oh, we can take up this matter on Tuesday. What is it?
As the first matter, Your
Yes,
Lordship.
yes.
Your Lordship, we have also filed two IAs. One was, we had a little defect in that cost title. I'll give the numbers if both the IAs can also come. Though they insisted that we should make the central body a party, but if I place, no relief is claimed against central body. We are not agitating against the norms that the central body has laid down. It's about the implementation part.
But the regional director of the central body, he's a part of the joint committee.
He may be the part of
He's
the
the-
joint
he's the
committee,
one
but
who has
all
conducted
orders are
the
by the state.
inspection, your lordship. And as
All the-
per
all
the
the
report,
others-
that inspection report, they have been disallowed.
What is that? What is
What if, yes, Your Lordship, what is under challenge is in fact, Your Lordship will see annexure 12, which is the Director of Technical Education and Training, which is page 35.
Yes, your lordship. That has been issued
Yeah, so that-
pursuant to the joint inspection done by the regional
Absolutely.
director of the
And that's
central
exactly
body.
what you were supposed to convey. You
which
did
is
not.
which recommendation made by whom?
Recommendation made by the regional director of your lordship. It is
No.
Joint inspection committee.
Yes, Your Lordship.
That was
Whether joint inspection committee is a party,
That's not
Joint-
really a body. They just formed few people.
it's not a
Yes,
body.
not,
alright.
not a statutory body. So the list over here is that you were supposed to supply the reasons you did not do so. You're sitting over the matter since last November.
So we will see.
the regional director,
Anyways,
who's
Your
a
Lordship.
representative of the Director General of Training, your lordship. He's headed that joint committee.
Maybe.
Yes, your lordship. And pursuant to the recommendations of that joint committee, your lordship, the OP number 3 has issued those orders, your
So
lordship.
OP number 3 is bound by that.
Yes, your
recommendation.
lordship. They're bound by that. Because this, it is bound by the norms of the DGT, your lordship. That's a central body, your
Norms
lordship.
of the DGT said that there'll be a joint committee.
Yes, your
comprising
lordship.
of
It
these
is,
members.
it is actually, it has stemmed out from the Ministry of Scheduled Castes and Scheduled Tribes and the Tribal Affairs Ministry. They have formulated a post-metric scholarship, your lordship. For that, they wanted verification of all the grantee aid institutions and also the private ITI institutions, your lordship.
Who stopped?
And they had enumerated certain conditions that had to fulfill for them to be registered in the portal, your lordship. For that, the Chief Secretary and the CAG of India on the previous records, what has happened and all, for that, they said that they should be verified and they should be all admitted into that portal. Then for that reason, your lordship, the Chief Secretary directed all the administrative departments and to the OP number 3 to conduct physical verification of all these ITIs, your lordship. 409 odd private ITIs, your lordship. After the initial report of all these government polytechnics and ITIs of the areas, they conducted the physical verification. After that, a report came, your lordship. After that report, they were issued show cause notices on 3rd of July. That by 9th of July, you state why you will not be allowed. Why will you be allowed to take admissions? Out of which those 47, only 28 ITI institutions, they replied to the show cause notice. And one ITI which has changed its locality without the permission, they also replied. Out of that, a joint inspection committee was formed under the regional director of DGT, your lordship. And they found out and they gave admission to 3 ITIs were allowed to give admission and the rest were disallowed. And F/3 annexure is a detailed account on why they were disallowed. Most of them, none, even though the register shows hundreds of students being taken admission, not a single student or staff was there when they were physically verified.
We will consider.
Yes, Your
Yeah,
Lordship.
Lordships,
Land documents
may I
were
just
not
say-
there.
May I just say one? The initial inspection was done in the month of December 2023.
In a phase-wise manner.
23. That report was never conveyed. That is why we made a representation that you are asking us to show cause. And that also after 6 months you sent us to show cause, give us the reasons. Very strangely, as she submits, the 29 of them did reply. We don't understand. And they have annexed all those show causes, which are word by word same. None of them have the reasons. None of them have the reports annexed. How did some of them get this benefit and we did not? It's something that have to be explained. None of the replies to the show cause have been annexed. 2, thereafter, they had a second round of inspection. There also, they did not convey the reasons. And that is why today we land up in a situation like this. And they admit and don't dispute that we have never supplied you the reasons. So without reasons being supplied, all these things have happened from December till here. We are not disputing that that these norms have to be followed. Very strangely,
All right, we will
they
hear.
have produced the inspection
Let the
report,
affidavit come.
the inspection report without anybody's signature on it.
So when was the order passed?
5th of August, Your Lordships.
Oh.
And thereafter also we made a representation. Give us the reasons at least. Because some of them may be rectifiable. Like the lease deed copy is not there. We could have rectified it.
Well, we'll see those.
My lord,
Your Lordships, IN number 11201 and 11200, if both can also be called.
my lord, item 13, same matter, my lord. My lord, what happened, I am the supporting of this, my lord. In mid of the session,
Support her on
support of the
25th.
association, my lord.
not 25th.
Item 39.
27.
Lordships. Your Lordship, within the first 5 matters.
Right.
And these IAs also.
Along with that 13,
39, my lord.
39.
And all other matters are there.
This association is registered.
These IAs are, yes, Your Lordship. Yes, Your Lordship. We've also annexed the copy of the.
My lord, what happened, my lord, all the ITs are old IT. Till 20 years they have existed. And in the meantime, they have taken admission. 30% admission is already taken. In the
Only
meantime,
30%.
30-40% admission already taken, my lord.
Only SC/ST.
No, my lord. General and all things.
First they blocked the SC/ST, rest were being allowed to be admitted.
Yes.
After
But
admissions are over.
Here your problem is those SC/ST students.
No, both the problems
madam.
have arisen.
Both, madam.
What they did is, instead of conveying us anything, first they blocked the SC/ST portal. Then the second round, without conveying us anything, they blocked the entire admission. All the conveying of the show causes also have come after they have taken the action.
And all in the mid of the session, they have disallowed the students, my lord.
While the admissions were going on.
Because all the IT, the affiliated IT, by the two inspection, my lord, the preliminary inspection and a standing committee inspection, and they have got the permanent affiliation, my lord, to all ITs, my lord. But in the mid of the session, they have issued the notice for the disallowal. That is the enter fact of the case, my lord.
Item number 5.
My lord, on the last occasion, we both learned counsel for the petitioner and opposite party had submitted that the parties are going to negotiate the matter, and they are on the process, and some offer have been given, and the petitioner is consulting one of his partners, not but family member, how much rent they have to give. So in the next date of meeting, they will give their revised offer and they may reach at a conclusion. So I request your lordships to adjourn the matter to after 2 weeks or 3 weeks.
And counsel for the petitioner states that the parties are making sincere endeavor to resolve the dispute between them, and steps have already been taken in that direction. So he has submitted that the dispute is likely to be resolved within 2 weeks. So let's this, as requested, let's this matter on 3 weeks.
Item number 6.
Item 6, no. Here in fact, two matters have been tagged together for disposal. One arises out of a proceeding in respect of a proceeding arising out of Estate Abolition Act under the special notification. And the second one is arising out of an encroachment proceeding. Two orders were passed in common, and thereafter to a revision application, thereafter two writ petitions. I have also filed a brief note of submissions.
Just may intervene here. My friend has filed this first writ application, that is 7687 of 2005, challenging the impugned order by the revisional authority only, Annexure 19. He has not challenged those orders, until and unless he impugns those orders, even if it's allowed, the other orders remains. So how can this be made? Your Lordship may kindly come to the prayer,
That is technical.
He has to amend. I only say, he has to amend his prayer. Otherwise, it may be difficult.
The order 19 confirms the other orders or sets?
No, I understand the mergers, but supposing the orders, revision order is set aside, and the orders of the original authority and the appellate are not specifically set aside, those orders remain even though it's mergers. So technically, he has to amend his prayer, That is my only submission, Not
We
that.
can mold the relief also.
We can set it aside if we set aside that.
That I wanted to bring to Lordship notice only,
What is the dispute about?
May I just place the brief
2005.
note of submission? There is a date set also in that submission. So that the background facts can be made clear.
There was an order for bringing on record the judgment in OJC 1765 of 1989. What is that?
Already filed.
That is there on record.
Yes. In an earlier writ petition, the matters were remitted back to the regional authority for consideration. But here the authorities have come to a conclusion that one order, the exchange order which will be in place, that has been set aside wrongly. That was wrongly observed. May I place the facts from the note of submissions?
Yes.
The petitioners are the successors of late Pranakrishna Mahapatra. The properties under dispute relate to the following. One set of properties I have indicated, two plots, 2386 and 2387. Property originally belonged to the intermediary Brahmananda Mahanti. The two plots were Gochar lands. Then another set of property, this is plot number 2359, this is 51 decimals. Property originally belonged to the intermediary Pranakrishna Mahapatra, the predecessor of the present petitioners. As in 31/1/1950, in discussion number 92 of 1948-49, a proposal for exchange of lands was sanctioned by the additional district magistrate. This is under Annexure 1. Then 21/2/1950, it was accordingly ordered that plot number 2386 and 2387 from Khatanam so be exchanged with an equal area out of plot number 2359 from Khatanam such and such in favor of Pranakrishna Mahapatra. This is under Annexes 2 and 3. In this order, however, Khata number so is mistakenly reflected. There is no dispute to that. Then Pranakrishna Mahapatra expired in 1958. 1965, in the subsequent settlement of the year 1965, the aforesaid two plots received under exchange, that is plot number 2386 and 2387, were recorded under three new plots in the names of the successors of Pranakrishna Mahapatra. I have given the plot numbers also. This is available in the Amins report of the single address number such and such in annexes 4, 5, and 6 of the settlement record, the documents of settlement records. In the 1980, before completion of the settlement operation, consolidation intervened. During the consolidation operation, the aforesaid plots were recorded under the following LR plots in the names of the predecessors, the successors of the Pranakrishna Mahapatra. Then I have given the plot numbers also, lastly recorded in the name of the petitioners also. Then one of the co-sharers of the family filed a partition case, that is number 215 of 1980 before the Assistant Consolidation Officer Chandor. The above details are available in order passed in this case. 11/12/1980, Assistant Consolidation Officer rejected the application on the ground that there is no settlement under the OEA Act. Even though the concerned Amin found the possession of the plots in question with the petitioners. Orders of the Amin report and the sketch map have been annexed
Annexure 7 and 8. Then 31/10/1984, a circular of the government of Odisha published by the Board of Revenue empowering the assistant consolation officer for settlement of the Bebandobst lands and other lands. That is under Annexure sign. I have annexed the notification also. In 1985, in portions of the above circular, the petitioners made an application before the assistant consolation officer come additional Tahsildar Kendrapada, which was numbered at OEA lease case number 44 of 1985. Then 1986-87, when the aforesaid lease application was pending, taking advantage of the situation, at the instance of some of the villagers, the Tahsildar Kendrapada initiated an encroachment case bearing EC case number so. Obviously, the petitioners have preferred objection claiming title in respect of the land in question. During pendency of the aforesaid lease case, however, encroachment case number so was disposed of, directing eviction of the petitioners from their residential house.
Instead of reading your submission, just tell us in brief, what is the dispute about?
Dispute is whether the plot.
And what is the legality in the order?
Dispute is not whether the plot should be recorded in name of the petitioners or it should be there should be eviction. Now, in pursuance of this circular of the government, I prefer the petition for settlement. That because earlier under the exchange order, the plots were given to the present petitioners and the petitioners.
Which order of the government?
Annexures. I have given an annexure, exchange order, annexures 213.
Annexure?
213. And
213.
I am placing it.
2 and 3.
Is the map.
I am placing the annexure 1 also. Sanction order page 21 of brief 7687.
Annexure 2.
May I place it annexure 1 page 21?
Annexure 1 is exchange as proposed.
Proposed, then next annexure 2.
So who is GN Tripathi?
Pardon?
Exchange as proposed by Sri GN Tripathi sanctioned.
Yes.
Who is GN Tripathi?
Then an authority. In the last admission, so. It is therefore ordered. The page 22, last paragraph, it is therefore ordered that the Gochar plot number such and such with an area of 47 decimals and 2387 with an area of 2 decimals in Khatanama such and such Mauda Aranga Malikeshwarpur may be exchanged with an area of 49 decimals of another plot number 2359. This order has never been challenged. And in pursuance of this
Just
order.
a minute, just a minute.
Yes, case map is annexed also to that order. Annexure 3.
So which power he had exercised? The additional district magistrate?
Act 1 of 1948.
Huh?
Act 1 of 1948 and that is also there in the appellate court's order, there is reference to that.
And this is an admitted fact. There is no dispute about it.
No dispute. And I am placing that appellate court order, that portion of the appellate court's order.
Just a minute.
Yes, section 3. This was prior to 1951, before vesting, these proceedings were being taken up.
Which section?
Section 3. There was a requirement of permission, then transfer.
Why?
Section 33, there is nothing.
Pardon?
What is there in section 3?
There is requirement of permission, thereafter the transfer process can be.
Where is that? This, you are referring to this act?
Yes. And then the reference to this is there in.
Reference, forget,
Yes,
show us
yes.
from the
Yes.
act.
I will place it. This subsection, may I place it? Notwithstanding anything contained in any other law for the timing in force or any other, any express or implied agreement, but subject to the provisions of subsection 2, no landlord shall, without the previous sanction of the collector, sell, mortgage, lease, or otherwise assign or alienate the or convert into royalty land any communal, forest, or private land, or create any occupancy right therein. So this was the basic provision for sanction of the collector. Then subsection 2, when a piece of land comes into the definition of forest as given in the Orissa Prevention of so and so, also and also within the definition of communal land or forest land as given in the Act, the previous sanction given by the appropriate authority under clause A of subsection 1 of section.
The question which we have put is, under what jurisdiction the additional district magistrate has passed the order?
Because there is a requirement that he should pass the sanction order so that the transfer can be effected. Under subsection 2, there is a requirement that the collector should give a sanction.
Read it again.
When a piece of land comes within the definition of forest as given in the Orissa Prevention of Forest, Private Forest Act, so and also within the definition of communal land. Here it was a gochar land, it's a communal land. The sanction given by the appropriate authority under clause A of subsection 1 or of section 3 of that act shall be deemed to be previous sanction as required by the subsection 1.
Why, there is nothing in subsection 1. This section has nothing to do with your case.
No, because the proceeding was initiated under a sanction order passed under this act, and thereafter the exchange was
So therefore, we have put this question whether the additional district magistrate had any jurisdiction.
The proceeding has been taken up under this, getting the jurisdiction
From
under
the
this.
very beginning. How can section 3 be invoked for exchange of?
Because the type of land was gochar, therefore a sanction order was passed first. Thereafter,
The type of your land was not gochar.
the other one.
The other one.
Yes.
Where is that provision?
Communal. It comes under the communal land.
A piece of land comes within the definition of forest and also within the definition of communal land or forest.
Gochar is communal.
Mr. Counsel, when a piece of land comes within the definition of forest as given in the Odisha Prevention of so and so, and also, so both conditions should exist.
Yes, ma'am.
Forest and also within the definition of communal land.
Yes.
Or forest land,
yes,
as given in this act, the previous sanction given by appropriate authority under clause A of subsection 1 or subsection 3 shall be deemed to be the previous sanction. So what is therefore we can read subsection 2 with subsection 1 of section 3.
Yes, yes, ma'am.
Yes, my lord.
Landlord shall refer the previous sanction of the collector shall mortgage, lease, or convert into
Of that act, I mean the
property that they converted into agricultural.
that language used is
You have taken it for cultivation.
no, for homestead purpose.
Read that sanction.
Pardon?
I don't think it is for butcher you have taken in place of Annavadi.
Yes.
Not for homestead.
No,
For
in the
cultivation,
order.
I think. Homestead is not really- Because it will be converted into royalty land.
It's not Annavadi Millards, not private land. Annavadi is also government. He says that it has become Millards,
Annavadi.
not fit for cultivation. That
So
is why
he-
I wanted to extend.
So
Millards.
he exchanged the Gochar land which is fit for cultivation.
Right, Millards.
So question of homestead, where does it come?
No, doesn't direct.
Cultivation.
Maybe, Milord.
This permits for cultivation purpose.
Yes, maybe.
All right.
But can the government take away the property which he received on exchange and again the property which they gave on the exchange? That is the exactly question. Now the property which was extended in favor of the government, that is recorded in the name of the government. Now which the property which he received on the exchange, that is sought to be taken away.
They are not returning your old land to you.
No.
But
Let me down.
Annavadi, was it your land?
If that be so, Millards, I will find out his land can be, if you also come to the earlier judgment, that is why also asked for the records of the original order, Millards, of 1992 or division bench, there is a clear finding that land cannot be exchanged. The order is illegal. May I read out that paragraph, Millards, of that?
Cannot be exchanged, but in his land, you have taken and given him some land, and then you say, give back your land, but you are not
No, we
returning
have not
his
given
land.
it back to. That is the finding of the, you also may read out that small paragraph of the
So he's in
WPC number.
Possession of both lands.
No, we are
That he is saying, Millards, I have to find out because I don't think government.
That means by this time should have been found out.
No, that was
No, there was not the question. Only question was whether.
That is the reason on the last orders you will also may find an inquiry was directed to the government to make an inquiry by the Tahsildar concerned and submit a report. At one point of time, the Tahsildar Kendrapada submitted a report saying that I don't have the jurisdiction now because it has been bifurcated. It is now under the Tahsil of Deravis. Again, an order was passed in pleading Tahsildar Deravis in this case and to submit a report. What is the condition on land and who is in possession? And no report has been submitted, no inquiry has been made also in portions of that order.
Where is that order? I've seen that order in pleading that Tahsil.
Yes, thereafter.
Order dated?
Even earlier.
Order dated 28/7/2023. There, 28/7/2023, you are permitted to implead him as a party.
Yes.
Then you filed and it was not there on record. Thereafter, on 25/8/2023, has been impleaded as a party.
Yes.
So extra copy of petition took 1 month to serve.
I have sought copies.
And who is opposite party number 5?
5 is, I think, the villagers that at their instance, in fact, because again, even against the encroachment order which was dismissed, villagers preferred appeal without the state. Yes, 5 is one of the villagers, private party.
5 to 8.
Yes.
So notice has not been sent to them.
Yes, they had appeared, I think.
No?
No, their notices were sent and they refused to.
Okay. Thereafter also they have. Long ago they have. Okay, 5 has refused.
So you are in possession of which land?
The land which got under exchange.
And what about the earlier land?
That has been recorded in the name of the state. Annexer, I have annexed that.
So you are not in possession?
No. And I have given the.
And what is the area?
Area is 49 decimals. That is also admitted by the state in a report, Annexer 10 and 11. 10 is the report in this proceeding, and 11 is the photograph I have annexed.
No, but again, the moot point is whether he had the power to permit
That is
exchange.
why, Millards, I was praying, if you also kindly come to Millards, that order of 1992 passed in OJC number, but there is a clear cut finding, OJC number.
1765.
Yes. Paragraph 3 of the order will also may kindly look at, Millards.
Where is that?
Millards, it has been given subsequently by an order
By
of the Supreme
additional
Court,
affidavit.
by of additional affidavit.
Page 301. Towards the end of.
Paragraph 3 of that order, Millards. The narration of facts as given earlier clearly indicates that notwithstanding an order of exchange allowed by the additional magistrate,
Where is that?
paragraph 3 of the order, my lord.
That is filed along with an additional affidavit.
Page 3 of the order.
My lord. The narration of facts as given earlier clearly indicates that notwithstanding an order of exchange allowed by the additional district magistrate in the year 1950, the said exchange had never been given effect to. On the other hand, on the date the land stood vested by virtue of the notification under the provisions of the Orissa State Abolition Act, the disputed land measuring 49 decimals appertaining to plot number 2386 and 2387 continued as gochar under the ex-mediary Brahmananda, and Brahmananda had given those lands in Ex-parte submitted by him. Thereafter, the lands continued to be gochar and the state was the owner. Once the exchange order in 1950 had never been given effect to, and the lands continued as communal land, the Undersecretary of the Government in the Revenue Department had no authority to issue any direction as contained in Annexure 9.
So this is regarding the same land.
Same land. And thereafter, subsequently, there will give opportunity given to him to appear before the appellate authority in the OEA proceeding, OPLE proceeding, and he should be given opportunity hearing. That is the judgment. So there is a clear finding that the exchange cannot be removed. If he says that he is not in possession of his original land, we will definitely restore it. Even record of right can be corrected in his favor. That I can also instruct the authority to do.
Thereafter, the relevant portion is encroachment appeal filed at the instance.
Exactly,
will be heard again. So what happened to that?
That is the subsequent connected read petition.
But the finding is very clear.
Yes.
Yes, my lord. Here the finding is that it has not been given effect to. That is why.
See, the finding of this court is very clear on the point that the exchange was not given effect to. The order was not.
That order is there. That order is there. Even that has not been challenged. I'm because ultimately the
exchange becomes meaningless.
Why I am submitting? Because here the subsequent proceeding which was initiated on the OEA Act has not been taken into consideration because under the circular, the petitioners were given an opportunity to settle the land to seek settlement of the land.
After this order, 4/9/1992.
No, prior to that.
Prior to after that, this is the finding.
No, that has not been taken into consideration at least in this, because this in relation to a.
So you could have challenged this order.
That is there. I have not challenged.
Then that is the finding binding on you.
But the ultimate order is to remand the matter to the enforcement appeal. Ultimately, the effect of the order, ultimately the land.
That was for the purpose of encroachment.
Yes.
It was not for the purpose of on the point of exchange. Just
With the help, you would not have bought the land and then said here it.
We are considering the legality of the order.
So that has not, even that aspect of the matter has not been considered by the land, both the.
That aspect was not there.
It is not there.
That aspect was not raised.
Let me be permitted to raise that again.
So you raise that, even you can raise before appropriate proceeding, not in the present proceeding.
Unless that is taken care of, I think the homeless, that will be.
What happened in that encroachment appeal against you?
That is also against me.
After that observation of this High Court, it has to be against you.
And that is the subsequent writ application which is annexed.
Exactly.
Both the writs have been tagged.
See, your entire case is based on Annexure 2.
Annexure 2.
And that does not survive because of this court's decision.
If that doesn't survive, then I'm entitled to get back the property which I gave on exchange.
You will have to claim or whatever. That was never your relief.
So that may be observed by your lordship, so that anything.
You may withdraw and apply.
Unless that is observed, that I may face no problem.
We can give you liberty.
Annexure 19 is that order?
Yes.
In encroachment appeal?
Yes, both common order.
Yes, common order. That's a common order. uh, uh, should I be given a chance so that I can revert back on Friday? No, may not be on Friday, Monday or Tuesday, so that I can take instruction in that respect. I'll
Seek instructions.
Yes.
Thursday.
Seek
Next
instructions.
week.
Otherwise,
Next week.
the order does not suffer from any thing in view of the division decision of this court.
That has been observed also. That has been observed. But the main aspect is, if a property has been given by me and that has been recorded in the name of the state, again which was given to me is being taken away. So what will be the effect? I will.
That is
I
not-
understand your lordship. I have to independently claim that. I know that. But this aspect of the matter has not been taken into consideration by either of the.
It's not taken into consideration because not raised.
Not raised, because I'm claiming that I have got the order.
No,
of
because
blocks on
this
the-
land is better, you prefer that this
Because
stays with you.
1950, the houses are there. May I kindly draw your lordship's attention to Annexure 11?
The houses, but another thing, this was given for Rayati purpose.
For-
Because it is fit for agriculture.
Maybe a part of it, it is not totally homestead. Still a part of it is agricultural. That photographs is there and the report is under Annexure 10 is there, who is in possession.
No, has it subsequently
It is a
been,
government's,
has it been subsequently converted into homestead land by order of any authority? No.
no, subsequent to record of rights, there has been consultation record of rights.
No, record of rights is already taking into account.
No,
but
no regular order of conversion is there. No regular order of conversion is
it's
not.
not there.
And counsel for the petitioner seeks adjournment to seek instructions from the petitioner whether to pursue this matter or not in the light of clear observation made by this court in the order dated 4/9/1992, passed in OJC number 1765 of 1999.
99 or 89?
89.
89.
Relevant. Paragraph 3 of which reads thus. Paragraph 3 report cover. So, as requested, this matter on Thursday.
Item number 7.
Your Lordship, on behalf of Mr. Ratha for the petitioner, we have no instruction. In the meanwhile, the matter has become infructuous.
Infructuous?
Land acquisition has been given effect to.
And counsel for the petitioner states that she does not have any instructions to press this application. First of learned AGA representing the opposite parties has submitted that this application has become infructuous. Infructuous. The application stands disposed of accordingly.
Madam, your name please.
IP Bose.
IP.
Again, Indira Priyadarshini Bose.
Item number 8.
The petition was dismissed for non-prosecution on 23/3/2007. Thereafter, immediately with 1 day delay, although there is no delay, but 1 day delay, the application for restoration was filed. Thereafter, the matter could not be listed. Then in 2018, pursuant to the direction of this honorable court, an application for condonation of delay was filed. Thereafter, today the matter is listed for restoration.
That is in 1992.
Justice Hansaria's judgment.
Yes, High Court rules.
That is there in lots of reported CLT in a High Court rule that citation is there.
But the name I'm not getting.
No.
The others you could have got it, might be there in the net. CLT कितने मौजूद हैं? मौजूद हैं?
Chapter 8, Rule 30 of the Odisha High Court rule doesn't provide for any limitations. However,
This application has been filed for the restoration of what is that? A restoration of WPC number 395 of 2002, which stood dismissed on 23/7/2007 due to non-appearance on behalf of the petitioner. Bracket, comma, State of Odisha. The present restoration application was filed on 3/4/2007. 2007. 3/4/2007. No, is it filed?
This one,
No.
CMPL. CMPL has been filed on
23/4/2007.
2007. Yes.
23/4/2007. Oh, stop. It appears from the records that the office note mentioned that time for filing of restoration application had expired on 22/4/2017. And therefore, the application for restoration was barred by limitation, comma, there being delay of 1 day in filing the restoration application. So stop. Restoration of WPC number filed under Article 226 and 227 of the Constitution. Stop. Pursuant to an observation made by this court, the restoration application was taken up for the first time 11 years thereafter on 4/4/2018, when time was granted by this court to file an application for condonation of delay of 1 day in filing the present restoration application. Accordingly, IA number 126 of 2018 has been filed for condonation of delay. Stop. That was enough. High Court rules. Next. In our considered view, however, an application for that in our considered view, however, the rules of the High Court of Orissa 1948 does not prescribe any limitation period for filing restoration application or restoration of a petition filed under Article 226, writ petition filed under Article 226/6/227 of the Constitution of India. Stop. This aspect has been dealt with by a division bench of this court in case of Bhattakrishna Behra and others versus State of Odisha and others, reported in 74/1992 CLT 337. The relevant portion of which reads thus. Book dekha tha na? So stop. Next. Considering the circumstance that the writ petition was dismissed for default because of non-appearance and the application for restoration was filed with all promptitude, this application is allowed. Let WPC number so and so be restored to its original file. Stop. The order passed in WPC number so and so dismissing the writ petition for default stands recorded.
That order of the tribunal must have been given effect to.
That I'll have to.
Where only the punishment was changed. Agreed with the findings, only quantum
Punishment not changed, punishment was upheld. But the Honorable Court directed further that his leave period, the period of leave which has been treated as extraordinary leave, has to be considered in terms of section Rule 23 of the pension rule, and he will be entitled for the pay
medical leave.
for that period.
And so punishment they have interfered with. Findings.
Punishment they have not interfered. So far as compulsory retirement,
Okay.
the Honorable Court said it is correct. The tribunal said it is correct. It cannot be interfered with. But however, further directed that in view of 23 of the Odisha pension rules, he is entitled for the pay, and that period has to be treated for the purpose of pensionary benefits.
Yes.
Let's see if the counsel is there and the opposite party is there. Let us see.
Well, item 9.
You should also get instruction.
I'll
File the petition for amendment of petition deleting the prayer of virus of section 75 subsection 4 of the Cooperative Tribunal, Odisha Cooperative Society Act.
In the present writ application, the petitioner had put to challenge the validity of section 75(4) of the Odisha Cooperative Societies Act, 1962. So stop. IA number 14451 of 2022. this application has been filed to delete the petitioner has also challenged an award dated 26/4/2006 passed by the liquidator in dispute case number 1 of 2000. Stop. By making this interlocutory application, the petitioner seeks to delete the deleting the prayer.
But the prayer and relating the submission relating with that at paragraph 14 by substituting, replacing another same paragraph 14.
Oh no, which IA relates to deletion of your prayer?
Well, 10495.
10495.
Flag B, man.
Huh?
Flag B of your lordships.
Flag B.
Flag B. It has been marked as flag B to on your lordship's file.
Flag B. Do you have flag B? IA number?
10495, my lord, of 2024.
10495 is not there.
Yes, ma'am, that is in the first title, my lord. It's called list.
Only 10495. IA number 10495. Application has been filed
There at last.
seeking amendment in the by deleting the replacing para 14.
14, my
Where is that?
Schedule.
in the schedule I have given. At page 3 of the interim application.
Seeking amendment in the writ petition. Stop. The petitioner seeks to substitute the the statement made in paragraph 14 of the writ petition by new paragraph 14 as mentioned in the schedule to this application. Stop.
Also the prayer portion, deleting prayer portion.
Delete.
Deleting paragraph 2 at page 4, my lord. I deleted that portion challenges.
The petitioner also seeks to delete the second line of prayer at page 15 of the writ petition to the extent the same relates to challenge to the virus of section 75 bracketed 4 bracketed A of so and so act, Orissa Cooperative Societies Amendment. Orissa Cooperative Societies Act. What is the name of the act?
Orissa Cooperative Society Act 1962, my lord.
Act 1964.
62, my lord.
62. Also considering the nature of relief which has been considering the nature of amendment sought in the present application, the same is allowed. IA number so and so stands disposed of.
Consolidated by on 27th, my lord.
Consolidated writ
By
petition.
27. On 27.
Consolidated writ petition they'll file.
You'll file a consolidated petition because those pages will go.
Yes, but he has to file in all three cases.
I consolidated writ petition by 27th August, my lord.
By
Because there is snag in my computer.
Along with the index.
Along with it.
20
With the
Index
numbers
is
you try to adjust.
along with index we filed by 27.
My lord, other two writ petitions share, my lord.
Different IA numbers are
IA
there.
number is different. 101 is 10496 and 10497. Other two requisitions.
Let these matters be listed before appropriate assigned bench.
Item number 10.
Regarding that, when the transfer deed, when the auction was commenced for 12,60,000, why the transfer deed is only noting that 6,08,000 has been reflected in that matter. My lord, my instruction is this, that the transfer deed pertain to only land, my lord, but the building and the machineries, my lord, total auction was for land, building and plant and machineries, my lord.
Yes.
For the land, my lord, it is 6,08,000, and for the building, it was 4 lakhs, and rest was for the plant and machineries, my lord. If my lord will see page 31 for a moment.
Yeah.
Page 31, my lord. Of the read, where my lord, the sale of industrial asset, that is land, lot number 1, measuring a 0.507
Page?
decimal, building, plant and machineries of the unit, La Glass Eyes, my lord.
Page 31.
Yes, madam, of the read petition. You have submitted your offer in BLDC meeting, the OSFC held on 19/3/2008 to purchase the industrial asset of the above unit taken under section 29 of SFC Act at a consideration price of rupees 12,17,000 only on the inclusive of the earnest money. Thereafter, my lord, the negotiation on the sale of assets, that is building, plant and machineries of the above unit was held on 19/3/2018, wherein you revised your offers to rupees 12,25,000 only on an outright purchase, which is inclusive of earnest money and security deposit of rupees 3 lakhs to purchase the assets of the captioned unit as it were in basis and whatever there is in basis. You had deposited rupees 3,06,000 as earnest money and security deposit towards the purchase of aforesaid industrial assets. In consideration of above, the undersigned is to inform you that it has been decided to sell the industrial asset, that is the land, building and plant and machineries of the above unit in your favor as it were its basis and whatever there is basis, subject to the following terms and condition and other usual terms and condition of the sale. The sale by price of the industrial asset, land, building, plant and machineries is 12,25,000. Apart from the EMD and security deposit of 3,06,000 deposited, you shall have to deposit the balance sale consideration is 9,18,000. My lord, this 9,18,000 he has deposited. Kalpana Mahapatra has deposited, my lord.
Enter cell consideration I have deposited and supplied, filed the copies, my lord, of the receipt, my lord, I have filed. Enter 12,25,000, 3 receipts I have supplied.
Also, I have the receipts.
This is the receipt, my lord. One is 2,56,000.
So there are 2 sale deeds.
There are
And
2 sale deeds.
another.
There is 2 transfer deeds. One is to lot number 2 and one is to lot number 1. Lot number 1, my lord, is the land which was sold at the price of 6,08,000. Rest amount includes, my lord, plant, machinery and the building, my lord. And the total comes to 12,25,000, which he has paid. And that too, my lord, the deposit was with us was 3,06,000, and thereafter he has deposited 9 lakhs
odd, my lord. On 24/3, my lord, 2008, he has given through a check, my lord.
File an affidavit,
My lord, I'll file that affidavit.
not filed.
Not filed, I'll file that affidavit if necessary. And my lord, I have the valuation report also. In a memo, I have done it, my lord. The valuation, my lord.
You are for whom?
Yeah, I'm for the purchasers, my lord.
Purchaser.
And I've deposited 2,46,000 and 60,800 and 9,18,200. Total around 12,25,000. I have deposited.
Bring it on record.
My lord, well, then, my lord, I'll bring it. I'll bring it.
My lord, let them file an affidavit because it contradicts the deed. Your lordship may kindly see annexure 14, my lord. Your lordship may kindly, that is the sale deed. Your lordship may kindly turn
That is
to
a
page
transport deed.
139. Now my land fund is submitted that the only land is sold, not the building or assets.
No.
Your lordship may kindly see 139
It is
page.
sold separately.
No, my lord, on the deed, I am showing your lordship. What is the deed?
So let him file an affidavit.
My lord,
then
yes,
After
yes,
serving copy
yes.
on you and then.
My lord, regarding my lord, lot number 2, I have filed an affidavit. I was directed by this honorable court by order dated 27/7/2023 and on 1/8/2024 to file the documents regarding mortgage of lot number 2. My lord, it is a simple mortgage by deposit of title deeds. And in pleadings, it is admitted. Also in submission that it is a mortgage property. So that, for that, I have filed an IML that is not come on record.
No, but on 1/8/2024, we said you're giving up because you didn't file the documents. So
No,
that
my
order
lord.
is there.
My lord, because it is not available, for that I have filed an affidavit, my lord, IA. Because it is simple mortgage, no documentation is there, only on deposit of title deed. And that is admitted that it is a mortgage. And this is also recorded by this honorable court order.
As requested on behalf of Orissa State Financial Corporation and opposite parties party number 4.
Yes.
List this matter on 1 week or 2 weeks. 2 weeks, so as to enable them to file additional affidavits.
Right. My IA is 10930 of 2024, my lord. That will come on that.
They will come.
Item 11.
May I please, your lordship?
You mentioned. Yes.
My lord, an order passed in a proceeding under section 68 of the Orissa Hindu Religious Endowment Act has been confirmed in revision, which is under challenge for reasonable court in this writ petition.
Yes.
But the prime ground on which it is challenged is that the very proceeding under 68, keeping in view the facts and circumstances of the case, is not maintainable, number 1. Number 2, your lordship, reasonable court, by order dated 19/7/2023, was pleased to formulate a question as to whether the documents that was filed before the Land Revisional Court, which has important bearing on the case in question, would have been taken into consideration or not, because those documents were not available in the original proceeding, 68 proceeding, and whether reasonable court also in 223 jurisdiction can take into consideration those documents.
Where are the questions framed?
And that question, my lord, is regarding jurisdiction that is raised by me all through. But so far as the question is concerned, order dated 19/7/2023. 19/7/2023, your lordship may kindly see.
19/7/2023.
19/7/2023, Your Lordship.
Who is for the other side?
My
I
length
am for
is
the
there,
outside, my lord.
but I have a.
This is a certiorari proceeding, my lord. This is a certiorari proceeding. The orders passed by the endowment commissioner. Lord, the assistant endowment commissioner as well as the commissioner of endowment, both the courts have concurrently held that it is the property of the deity. And there is absolutely no infirmity in the order passed by the courts below. Whatever I have filed an application under 68 with the pleading that it is the property of the deity and they are in unauthorized occupation over the property. And he has filed his objection to that. On the basis of the pleadings, matter was adjudicated, and upon adjudication, both the courts have concurrently held that it is the property of the deity on the basis of materials available on
Just
record.
wanted to know whether you are present or not, and you have started.
Milord,
You are asking if anybody has appeared for the opposite party.
I am for the deity.
Yes.
I am
You are for
appearing
the-
for the deity.
Yes.
I am appearing for the deity, Milord.
Yes.
Milord, the now.
Let him argue.
Yes.
My lord,
Yes.
I have filed a written note of submission with your lordship. With your lordship's kind permission, I'll place that. Before that, only two aspects I beg to point out. One is with regard to the fact that I have raised the very jurisdiction, exercise of power under section 68 whether permissible in the facts and circumstances of the case. And secondly, these documents which pertains to a suit intercept between my vendor and the DT institution, whether this can be considered either by the revisional court or by this noble court in exercise of 226 power. These will be the two aspects I will be placing and assisting your lordship. Now, with your lordship's kind permission, may I place the written note of submission which will make the
Why
fact-
should you press? Let us understand the first. What is the issue involved?
My issue is this.
So why which order is under challenge?
The order passed by the revisional authority under Annexure 1 at page 11
This order has been passed by whom? The Commissioner Endowment.
in exercise of revisional power, your lordship. And the order under Annexure 2, which was the original, that is original order that is under section 68 of the Act, is under challenge.
So who had filed the revisions?
The revision was filed by me. The original proceeding under Annexure, the order passed in the original proceeding under Annexure 2 at page
Revision
18.
was filed by you.
Yes.
So you cannot question the jurisdiction of the Commissioner Endowments to entertain your revision.
No, I am not questioning the jurisdiction. I am very questioning the very initiation of the proceeding under
Initiation.
Much.
Right.
That is under Annexure 2 at page 18 in the facts and circumstances of the case. Where there are two provisions available under the Orissa Hindu Religious Endowment Act for eviction. One is relating to trustees under section 68, which is the present proceeding. The other relating to any other person under unauthorized occupation, that is under section 25. The advantage in a 25 proceeding.
What is there in section 68?
Madam, may I place it, madam? May I place it, madam?
Yes, we have seen.
Madam, this is relating to a trustee or your lordship, if your lordship also peruses the explanation, a person claiming under an alienation contrary to subsection 1 of section 19 or 24. There are two aspects, my lord, that has been also dealt with by reasonable court. Here, I am claiming my right on the basis of a purchase from a person against whom the DT institution had instituted a suit and lost. Ultimately, finally, it ended in that was a case of redemption, claim of redemption, but that has been dismissed all through. Those are the documents that were sought to be brought on record before the divisional authority. So here, my occupation can at best be termed as an unauthorized occupation in terms of section 25. I not being a trustee or in that sense any other that has been mentioned in the section 68, a 68 proceeding is not applicable to me. And the reason for objecting to that is, if an order is passed under section 25, under subsection 2, I have a right to file a suit to declare my title, which is not there in 68. So a 68 proceeding, my lord, is in respect of trustees. So far as this 25 proceeding is concerned, it is there because I can also claim adverse possession, whatever else relief is available. And 25(2) specifically gives a right to the person who is in unauthorized occupation to file a suit. After a requisition is made by the collector on the basis of the order passed by the Learned Commission of Endowment for recovery of possession. At that time, the cause of action arises for filing a suit. So therefore, the objection to the 68 proceeding. Your Lordship has seen, so far as this case is concerned, it is not the case of the DT that this is the petitioner before your Lordship is a trustee or anything that sort. Your Lordship will find from the petition that has been filed at Annex 3, page 29. And this petitioner, through their forefathers, have been staying in that property since the year 1950, your Lordship. And the adjacent properties have been settled. No litigation except barring one litigation is pending with regard to eviction. There are a patch of land, my lord. Only two, in respect two patch of land. This writ petition, I think there is one more writ petition
So
where
whether any order was passed under section 25 too.
No, here, my lord, the 68 proceeding has been filed, no 25 proceedings. So therefore, I am saying this is not maintainable because I am not a trustee. So a 68 proceeding against me is not maintainable. That is my stand, my lord. And in fact, your Lordship will find from my show cause, Annex 4 at page 33. I had also taken a plea of jurisdiction. Page 35, your Lordship may kindly turn to paragraph 13 and 14. The Honorable Court has no jurisdiction to try the suit as the suit property never belonged to the DT. The suit is even otherwise not maintainable and liable to be dismissed. Then I filed also an additional written statement. There in paragraph 4 also I have taken a plea that this is not maintainable.
So where is the proceeding under section 68?
68, that is my Annex 3 at page 29, your Lordship.
So from whom did you purchase?
I purchased from one Krishna Patra.
So Krishna Patra was not a trustee.
Krishna Patra was not a trustee. And they also instituted a suit claiming right of redemption. That suit, my lord, traveled to this noble court twice. And all, that is what is the my lord, document sought to be produced to the revisional authority. And I have given in the written note. My lord, it got dismissed. Ultimately, my lord, they didn't get it. Even my predecessor, Tiny, was also a party. My lord, he was defendant number 19, your lordship, in that proceeding.
That was not the pleading in the court below.
In fact, that was produced through the revisional authority. That was not a pleading in the court below.
Yeah, what is your submission on this?
My lord,
What is your submission? He says that 68 can apply only when
my lord, 68, he has not placed the section before your lordship. Your lordship may kindly.
68 we are reading.
68, my lord. Section 68.
Yes.
My lord, your lordship, see, putting the trustee or executive officer in possession where a person has been appointed as a trustee or executive officer of a religious institution to discharge the functions of a trustee of a religious institution in accordance with the provisions of this act, or as the executive officer in any scheme settled under the provisions of Orissa Hindu Religious Endowment Act 1939, and such person is
Just a minute.
registered.
So these are three classes.
Your lordship
are
may go
only
further, my lord.
Just a minute. Just a minute. Up to this, see, we will have to read the section like this. So here, after A, there is or.
Yes.
After B again, there is or. Then C comes.
Yes.
And after C ends with Odisha Act 4 of 1939, and such person is resisted.
Yes.
In or prevented from
obtaining possession of the religious institution or of the record, accounts, and properties thereof by a trustee.
By.
Yes.
Start from here. By.
Yes. Yes. By a trustee, office holder, or servant of the religious institution who was dismissed or suspended from his office, or here is important, or is otherwise not entitled to be in possession or by any person.
Mr. Please read it this way.
Yes.
By a trustee, office holder, or servant of the religious institution who has been dismissed or suspended from his office.
Yes.
Or is otherwise not entitled to be in possession.
Yes.
So such trustee, office bearers, or servant not entitled to be in possession.
Yes. Or by any person.
Yes.
Or by any person claiming or deriving title from such trustee, office holder, or servant other than a person claiming in good faith to be in possession of his
So
own account.
he is not claiming or deriving his title from a trustee, office holder, or a servant.
Yes.
He is not claiming that.
No, no, any person deriving or other than a person, title from such trustee, office holder, or servant, other than a person claiming in good faith to be in possession of his own account on account of some person not being such a trustee, office holder, or servant, the assistant commissioner concerned shall, on application by the person so appointed, direct the delivery of possession of the religious institution and its endowment or records, accounts, and properties thereof, as the case may be, to him in the prescribed manner. Any person, my lord, there is
There are three things. One, should be interested. Office bearer or servant. Office. Executive officer.
Yes, my lord, of the duty.
Yes.
Then your lordship
Yes,
kindly
yes.
find the
C, he will come under what?
my lord,
C, which category does he come under?
executive officer, my lord. He is the person, my lord, here by any person claiming or deriving title from such trustee, office holder, or servant other than a person claiming in good faith. He is claiming in good faith that I have purchased the property.
So it's good faith or bad faith?
He is it is obviously bad faith because no permission from the endowment commissioner, my lord. Under section 19, permission is required to be obtained while purchasing the deceased property. There is no permission.
What is this good faith?
Lord,
Apply in good faith. He can say I am actually holding good faith.
Other than a person claiming.
Good faith person is exempted. You cannot ask for possession from a good faith person.
as your lordship knows, there is a provision under section 19 under the Hindu Religious Endowment Act.
Permission.
Yes, Lord. If someone purchases the property of the deity,
Prior permission.
he has to obtain prior permission from the endowment commissioner. Here there is no permission.
But this is before the division bench decision or after?
My lord,
The division bench decision which said permission was also necessary for the other sort of property. This is purchased before that or after that?
my lord, after that, it is in 1950, my lord. Admitted case is he has purchased in 1950. The enactment is from 1939, my lord. He was citing a decision that is a free act, my lord. And adverse possession, it is a minor, perpetual minor, my lord. There cannot be, one cannot claim adverse possession against the deity, my lord. His alternative plea is adverse possession. He has to point out the infirmity and infirmity passed by the order.
So is there any decision on this, whether this provision has been interpreted, section 68? Interpreted.
I have given that citation. And I will only humbly.
That is prior to the enactment.
I'll only humbly pray, your lordship may also kindly peruse section 25 so that the contextually the appreciation will be, because if your lordship peruses section 25, what your lordship has been pleased to point out, that trustee or anybody claiming under a trustee, any unauthorized person or 19 violation transfer are dealt with under 25, your lordship will see. That much I beg to point out. Your lordship may kindly peruse 25, then I will place decision on the point. 25, man.
No, but that provision of that subclass C, that covers everybody. What we
68
found that or, it covers everybody.
Man,
Except somebody in doing it in good faith.
it must be under a trustee. That's not lacking in the present case. And that's not the pleading of either of the parties. And your lordship will see section 25. Then, my lord, the section 25 becomes redundant. But that is why, my lord, your lordship will see, in case of any alienation, in contravention of section 19 of this act or section 51 of the Orissa Hindu Religion Act 1939, or in case of unauthorized occupation of any immovable property belonging to or given or rendered for the purpose of any religious institution, the commissioner may, after summary inquiry as may be prescribed, and on being satisfied that on any such property has been so alienated or unauthorized occupied, send requisition to the collector of the district to deliver possession of the same to the trustee of the institution or a person discharging the function of the said trustee. The collector then, in exercising his powers under subsection 1, shall be guided by any rules made under this act. Any person aggrieved by the action of the collector may institute a suit in the civil court to establish his right. Therefore, here it deals with an unauthorized occupation. So, if at all their case is to be accepted, it's an unauthorized occupation. But in the civil suit, with the documents of which I have filed for the reasonable court, also for the tribunal authority, it indicates that they have lost. The courts have held that you have no right
You
to
cannot
claim.
file civil suit.
But I can only file civil suit if it is a 25 proceeding. This is a 68 proceeding. That is why I am submitting that 68 proceeding is without jurisdiction. Had it been 25, I would have got an opportunity to file a civil suit to establish my right.
No, that right you have always. Not that.
This is a statutory right. That is what I beg to submit. 25 eviction gives a statutory right, whereas the other one is to be.
Yeah.
Yes, where is that decision?
That I have filed, my lord. It is available in your lordship's record.
Yes.
That is your lordship will see the decision reported in AIR 73 Orissa. My lord got it? That first decision. My lord. May I just place, my lord, the relevant paragraphs?
Party name?
My party name is Radha Mohan Mahapatra and another versus Commissioner of Endowments and another.
Yes.
My lord, I'm placing from para 1. I'll only place few portion of it. My lord.
No, how the provision has been interpreted?
Interpreted, your lordship will see. Section 68 has been interpreted at page 4, paragraph 3. So far as applicability of section 68 of the Act to the case of the petitioner is concerned, the language of the section clearly shows that a proceeding under section 68 can only be instituted against a trustee who has been dismissed or suspended or is otherwise not entitled to be in possession when he prevents the newly appointed trustee from taking possession of the endowment properties. Further, section 68 of the Act has no application against a person who claims the property in good faith on his own account. Explanation to section 68 of the Act says that a person claiming under an alienation contrary to section 19 or 24 of the Act shall not be regarded as a person claiming in good faith. In the present case, the alienations in favor of the petitioners being prior to commencement of the Act, it cannot be said that the alienations in favor of the petitioners are contrary to either section 19 or 24 of the Act.
Yes, he appears to be correct in his submission.
My lord, this decision is a pre-act, my lord. By then, there was no enactment of Endowment Act, my lord. Here, the transaction is after the enactment in 1950. It is prior to 27.
No, but
here in this case, my lord,
section 68 has been interpreted. Section 68 of the Act has been interpreted in this decision.
Keeping in view section 19, my lord, they have discussed the person in good. The explanation to 68 of the Act says that a person claiming under an alienation contrary to section 19 and 24 of the Act shall not be regarded as a person claiming in good faith. Here, my lord, because the section is not applicable. Section 19 is not applicable.
The main difference between 68 and 25 is that if an action is taken under 68, he cannot question, he cannot file a suit because suit is barred.
Suit is otherwise barred, my lord.
Suit is barred under section 68.
No, my lord.
And 25 gives him liberty to file a suit.
My lord, the argument which has been advanced, that is a wrong proposition, my lord. Because he cannot, since it's the property of the deity, suit is not maintainable. At best, he can file an application under section 41. There is a provision under the act, under section 41.
Therefore, Mr. Counsel, there is a difference. Why? The section 68 shall apply. Yes, if the
Submission before a lordship.
See, the entire submission depends on the interpretation of section 68.
Whether
Whether for application of section 68, it is condition precedent that the person in possession should be either a trustee or servant or whatever who has been suspended, or
yes,
someone derives title from such trustee or servant or something.
So he has bought it from whom?
There must be some connection between the person who is in possession with the trustee of that trust. All right, either trustee or servant or something.
Or any person, my lord, it has been stated that any person claiming the property on good faith.
All right.
That means he has purchased the property from the competent authority by permission. That is, my lord, if it is under permission on good faith, the 68 is not applicable. Here, my submission before your lordship is that it is not in good faith. He has not, it is without permission.
Who has he purchased it from?
My lord?
Who has he purchased it from?
He has purchased from Krishna Naik.
Who was Krishna Naik?
I do not know who is the vendor. His vendor is Krishna Naik, my lord.
You don't know means if the vendor was not.
It is the property of the deity. It is not the property of Krishna Naik.
All right. So how can he establish his right?
My lord,
now, according to just think of a situation where you take a decision that see, this is the property of the trust. Wrongful occupation of a person A. All right. Now you take a decision, you remove him. He does not have any remedy. Then where will he go?
He has to file an application under section 41.
What is that, 41?
Yes, I will show it, my lord. That was available with him. He has not resorted to it.
Just let us.
Section 41. Assistant Commissioner to decide certain dispute and matters. In case of dispute, the Assistant Commissioner shall have the power to inquire into and decide the following dispute and matters. Whether an institution...
So he shall challenge the order of the endowment commissioner before the assistant commissioner.
Miller?
He should challenge the order of the endowment commissioner before the assistant commissioner.
Yes, he has challenged the order, my lord. The order which was passed by the assistant commissioner, that was challenged before the commissioner and he lost there. Both the courts have concurrently held that it is the property of the deity
Initially, the application by you was filed where?
before the assistant commissioner, my lord.
Okay. So both held in your favor.
Yes,
Assistant
Lord.
Commissioner thereafter. That has been.
This
evidently
41 gives the power, my lord, to the jurisdiction of the assistant endowment commission to adjudicate. If he is claiming that it is his personal property, not the property of the deity, he has to file an application before the assistant commissioner. He has not resorted to it for last so many years.
No, but does it cover all these, can the assistant commissioner decide it under section 41? Where is it?
Yes,
Where?
my lord, whether an institution is a public religious institution, whether an institution is a temple or not, whether a trustee holds or so and so, any person, then whether any person is entitled by custom otherwise to any honor.
Counsel, this power could have been exercised by the assistant commissioner while considering the taking up the proceeding under 68.
My lord,
He has all the powers.
he has exercised the jurisdiction under section 68, my lord.
So where is the question of him going again under section 41?
He has to, if he is saying that I have a right over the property, I could have approached the civil court. Civil court is barred, my lord, because it is the property of the deity.
All right.
He has to file an application under section 41.
All right, because of
Subclause G, my lord. Whether property or money has been given.
Mr. Counsel, we have succumbed to your pitch.
Yes.
All right.
Yes.
Please tell us why section 25 was not resorted to. Whether section 25 was there or not. So whether that could have been resorted to or not. If he was in illegal occupation position, then whether you could have applied section 25 or not.
Section
Tell us.
25
In case
should have
of-
been.
In case of any alienation
Yes.
in contravention section
Yes,
19.
yes, Lord.
So you should
That,
have done that. You can
But
do
he
it.
has never challenged that. He has, after the order was passed with regard to jurisdiction, at the threshold question of jurisdiction, when the matter was entertained by the assistant commissioner, prior to that, he should have challenged that on the.
Who should have challenged that? Instead of invoking section 68, why did you not invoke section 25? That is a simple question.
That is a proceeding, my lord, that I cannot improve upon, my lord.
That you cannot improve.
In fact, it is a proceeding under section
No, you
68.
cannot improve, you can still file.
Yes, Lord.
We will grant you liberty. We will grant you liberty to invoke this. This is our tentative view. We will write a judgment in your presence. And
Two things I will say, my lord. His sale is in contravention of section 19. The decision which.
sale may be in contravention. You are not to declare. You cannot declare. All right, he should have also some right.
Under section 41.
So even the suit is barred. If an action is taken under section 68.
He should have filed an application on section 41, my lord.
41 application, that is enabling clause. Section 41 does not speak of making of an application or filing of an application. That enables assistant commissioner to decide the disputes. You see the language of section 41. So in any proceeding, like in a proceeding under section 25, in a proceeding under section 68 also, in any proceeding, that are the powers vested in the assistant commissioner that he can exercise, he can adjudicate upon.
41, whether it is covered, I have my doubts. Because it specifically describes what are the disputes which can be decided.
My lord, so for property, if somebody is claiming it is my personal property, it is not the
dispute. No, in case of any dispute, assistant shall have inquiry and decide following disputes. So following disputes, if any proceeding is there, under section 60, in that also,
Actually, under that 68 also he could have gone.
he could have, or in any
But-
proceeding.
It's squarely covered. This is it.
Mhm.
Isn't your case squarely covered by 25? Because it says in case of any alienation, in absence of section 19.
My lord, in absence of section 19, my lord, there is no permission, my lord.
Exactly, that is what you are saying. Isn't that the provision of section 25? That in case of any alienation in contravention of section 19 of this act or so and so, or authorized, then the commissioner may after summary inquiry as may be prescribed on being satisfied,
Both are summary proceeding, my lord, 25 and 68.
that the assistant commissioner, here the commissioner.
Assistant Commissioner, my lord. Both are summary proceeding, my lord. Section 25 and section 28, both are summary proceeding. Both are to be adjudicated by the Assistant Commissioner of Endowment, and revision lies against the order before the Commissioner.
The only difference between 25 and 68 is
Trustee or representative.
no, that is one. The other aspect is that in 25(2), the person aggrieved can file a suit, and 68, the suit is barred.
My lord, no, my lord. That is not the correct position. Because since it is the property of the DT, he cannot resort to the remedy before the civil court, my lord.
No,
He
regarding
cannot file a suit for declaration that it is my personal property.
It is property of the DTV. You have decided unilaterally.
It is, no, my lord, I am the recorded owner. I am the recorded owner. The plot, my lord, it stands in my name. The person who has sold the property, he has no alienable right.
Next Thursday, further.
The next
My
item,
lordship,
item number 12, my friend is
Your
the
lordship is closing it.
Next Thursday.
But the next item, my
12, we will also take it up next Thursday. We are not so, here only adjudication on the question of not the Board of Revenue's order. They said that not there was the earlier direction by the Honorable Court to give an opportunity hearing and record a finding with regard to limitation. They said that it has not been done, and it has been, order has been passed by the Board of Revenue in contravention of your lordship's earlier order. That only I will examine next Thursday, or also may take it up, item 12.
Lord, item 13, my lord. Item 13 on behalf
We
of
will take up, we will come.
my lord, Mr. Mahatra is suffering from dengue, my lord.
Who?
So for that reason,
All right, when do you want?
my lord, next week or
All right.
2 weeks after weeks. Oh, bless.
Entry model is continued.
Yes, item number 23. He is somehow ill. In matter 3 weeks time may continue.
How much?
3 weeks time. Preferably on 12th of September.
Let the matter be called. Please be here, we will adjourn. Let someone be here when the matter is.
Okay.
May I have leave to mention, my lord?
Yes.
Item 48. My lords were pleased to direct, this is a review application where my lord are pleased to direct the state government to take instructions in the matter. A judgment of this honorable court, my lord, ex-parte without notice had passed an order. My lord, the state has filed their response.
Yes.
And notice has not been sent to the other parties. Page 48, my lord. My lord, subject to pleasure of my lord, can it be called sometime, my lord? We may not reach today. Any date, my lord, may fix.
Not read?
48, my lord. State has filed their response.
Yes. So what do you want?
My lord, may fix a date, my lord, and notice has to go to the other parties also, my lord. The other parties, notice was not.
Then you will have to wait, sir.
Yes, no, I'll wait, my lord. I have no problem about waiting today, my lord. In event it doesn't reach, my lord.
We'll fix a date. If it is
Yes.
not, if it is not taken up today, we will surely fix a date.
I'll be deeply obliged, my lord. That is all I was requesting.
My lord, item 24, I pray for a withdrawal matter.
Oh. You can write. 48 weeks. If it is not taken up.
Twenty-four. Your name, please?
Mandasunjan Naik.
Okay, now.
Plus item number 40, your lordships wanted to take it at 2 o'clock. In fact, I am extremely sorry about that. Two contents today. I received complaints in respect to, but that is not in respect to the present petitioner. Lords, in fact, someone demonstrated us. He is a lecturer. So I pray next Thursday, because matter has been now confirmed by the Honorable Supreme Court. So next Thursday, Lords, I will see that it is complied with. Lordships are pleased to grant me time
Item
on
40.
11. Item 40, Lords.
All right.
All that we want is a compliance because he's not getting pension because of this break-in service. He's not getting pension. That is the whole problem.
Yes,
So let him. I hope.
Let's this matter on 2 weeks as requested by Mr. Samantal and AGA representing the contemners so as to seek instructions as regards compliance of this court's order, violation of which has been alleged in the present contempt application.
29th.
2 weeks.
2 weeks. Hello, dear Lord, they are already granted, your lordship are already granted on 11/7/20.
All right, 1 week.
Much obliged.
From 15. 49.
Item number 49.
I have submitted the report. Last week, I directed the government to make an inquiry and submit a report. I have gone through that report, my lord. I found the submission made by the learned counsel appearing for the university is not correct.
Maybe.
It's beyond his instructions.
So what is the minimum qualification?
Was it PhD in law? Minimum qualification, was it PhD in law as per the
PhD or net? Where is the advertisement?
As per the advertisement, that was.
Yes, Manoj, I have the advertisement.
What was the qualification? All right.
The report says, PhD in law with 5 years of teaching for a principal and assistant professor, PhD in law, LLM with 1 to 3 years experience.
PhD is not.
But there is no, except 1 or 2, there is no person qualified.
Lord, that is not the ground to
Here, my lord, point is, my lord, the government has granted 64 seats, allocated 64 seats.
That is not the question. The question is we are in writ jurisdiction.
Now they have
We
reduced it
can go
to
beyond.
30. This time they have not granted. And there is no in the meantime, they are also granted affiliation. And affiliation was granted on the last occasion much after the admission was over. All admission, procedure were followed. Whatever that is approved by government.
So what do you want in the present application?
My application, my lord, I have been granted recognition by the government, my lord, for 23, 24, 24, 25, and up to 64 seats. Last time they have reduced it to 30 seats, and the government has made admission in respect of the private college doesn't have any right to make any admission, my lord. Last time 59 students were admitted against 64 students. At the time of examination, the university imposed a condition that you file an affidavit that you will not go for fresh admission 24-25.
No, in fact, we intend to direct that your recognition should be cancelled henceforth, and your recognition should not be granted, and in no case affiliation should be granted.
This year, my lord, already LLB admission is over.
Admission you should not have taken. You should not have taken admission. File your response. Otherwise, you are in serious trouble.
They have filed my.
A copy is there with you or not?
This report.
You deal with it.
If I will not get admission.
No, your college will be closed, mister. Under the orders of the court. Pursuant to the court's order dated 28/2024. The Commissioner cum Secretary to the Government Higher Education Department has filed an inspection report in respect of Bhubaneswar Law College, Kalinga Market, Nayapalli, Bhubaneswar. The report discloses patent deficiencies in running of the colleges in the college to the extent it relates to the faculties working in the college. Qualification of the faculties working in the college. And their manner of selection. Stop. A copy of the said report is in possession of learned counsel for the petitioner. Stop. Let the petitioner file an affidavit dealing with the contents of the said report by 1 week. The court will consider passing appropriate orders based on just taking into account the stand which the college may take in its affidavit to be filed pursuant to today's order. File.
This is relating to admission for this
This
year.
is, Mr. Therefore,
And this time also we have made advertisement to get a better candidates.
Mr.
We are established college, my lord. Out of 10, my lord, we are having 2 PhD.
We are very serious when we are making this observation that after having seen this report, we may direct closure of the college and your college shall be closed by a judicial order. No decision to be taken by any other authority. You are committing fraud on the No, he will file. He will file affidavit. You file affidavit. You deal with the report.
Just now I got the report.
Yes, yes. You deal with the report, file your affidavit. University will do whatever they want. First of all, you will have to
My lord,
satisfy.
some important aspect, my lord. The syndicate has
Mr.
taken a
Counsel,
decision, my lord.
forget syndicate. How can you teach students if you don't have qualified teachers? That is the most fundamental.
That's why
They may have committed fraud. They may have committed. How can the government grant you
The High Court
recognition?
Committee of both the organization have taken,
State all that, give those annexure, we'll see.
but unless we take an admission, my lord, it will be derecognized. My difficulty, I will not claim any equity.
Your college should be closed. If this report is correct, then it's your close. You
Face difficulty if you admit them and then they can't appear in the
Last time
examination.
we have
This is the
admitted,
problem.
in fact, we are not doing anything. Actually, government is doing this through a computer agency, my lord.
that is the whole problem, that you are not doing anything. You don't have teachers. You did not advertise. You appointed teachers without any advertisement.
Advertisement is
Advertisement later you appointed teachers without any advertisement. All right, file your affidavit. We'll see.
Item number 14.
14 minutes legal loss. All right, on last occasion, my lord has directed the OP number 2 and 4 to file their response.
Permission, my lord. I'm appearing for the opposite party number 2 and 4, my lord. Indian Oil Corporation, my lord.
Yes, just a minute, just a minute. Yes.
One of the concerned officer of the opposite party was on medical leave, and we have received the parawise complaint, my lords, yesterday only. I just seek only 10 days time, my lords. In between that, I can find the.
It's 2011 matter, counter
lords,
affidavit
but,
has not been filed.
My lords, the case was initiated in 2011, but it was noticed to the opposite party only on 2022, my lord.
20?
22, my lord.
So 2 years you'll take.
Just a last chance, my lords. Already we have received.
1 week you take.
As requested on behalf of the opposite parties. Opposite party number?
2 and 4, my lord. 2 and 4.
2 and 4. List this matter on 2 weeks. Stop. Let a counter affidavit be filed. In the meanwhile, after serving a copy upon learned counsel for the petitioner, learned counsel for the petitioner shall be at liberty to file rejoinder with said counter affidavit if so required. So do it in advance.
Item number 15.
I have 15 years also.
15, sir.
I beg your pardon.
Item 15, my lord. In fact, the matter arises out of a survey settlement order. In fact, it's a order under the Orissa Survey and Settlement Act. Assigned to Honorable Single Judge, my lord. I don't know why it should be.
Why this matter is there any order?
In fact, it's assigned to court number 23, man.
Earlier it was, because earlier it was taken up by a revision bench. Therefore, possibly.
Mutation appeal, my lord. It's a mutation appeal, so automatically it should go.
It has been rightly.
Some order passed in OJC WPC 10376 of 2015 is there here attached to this along with the restoration application and some review order.
At that time, my lord, it was.
No, it is case number is different. Why is there that on record? WPC 10376 of 2015. The order is there. So I thought that maybe this is the matter. This the number does not tally.
No, what is the case number?
16648.
16648.
16648 of 2011, my lords.
Hmm. 6/10/2016. So is it a batch matter that the order was passed in this case and other cases? Definitely. Tag duty. There's an order here along with that review application.
No, review was different, Lord. The original writ application was disposed of once, saying that he should approach the revision authority. Thereafter, they filed a review application to recall.
This record.
Oh, no, my lords, that is not.
Maybe was a common order passed? At least our order sheet shows that.
And so for 10376 by 2015 is concerned, in that case, the order was passed that similar application was disposed of.
Similar.
Similarly touching on that.
So that was reviewed. So this again was.
So we said that in review application, this is not similar to that case.
No, please come to the order dated 6/10/2016.
That is in the other one.
6/10/2016, 16648 of 2011.
No, 16648 is this matter, but the order is.
Achha, why is that?
That is what I'm asking. Earlier it was before the single bench. Thereafter. Sixteen orders were passed till 21/1/2015. Thereafter.
No, but this writ petition was disposed of by an order dated 6/10/2016.
Yes.
Why it has been listed again?
Thereafter, my lord.
Review only 10376.
This also is that review this only. 10376.
0376.
So the order we are seeing of 6/10/2016 is 10376. And it's asking whether common order has been passed or not. No. This is this. Order is 10376.
Or that review order is only 10376.
This order is also 10376.
No, this order is 16648. And so what is order number 7 in the writ petition?
In 10376, order number 7 is there. This is the order number 7.
Because the place.
And no order was passed in this.
Original file. Because here, until that order, 14 orders had already been passed. Okay, what a file was. Not absolutely. Oh. There are review of that order. What the order has been.
Why this order has been typed in this?
That's in the order sheet. Maybe office.
Why that has been typed? No, this matter was not disposed of. Just.
Single.
In 10376 by 2015, one line is there.
Where?
All the connected matter.
Listed together.
Okay, so this has been disposed of. Application was filed and that 10376 was restored.
That's same. But we are not able.
But
to
what
find-
about this 16648?
Yeah.
Any that I've seen.
This is the review. But why was this?
All right, forget.
Yes, that is there. 10376 is there. Why it was placed here, we are trying to see.
Yes. It appears from the records that the list this method before appropriate. Before the assigned bench as per the roster. So that is the only thing.
I think because this it was fine.
Yes.
Item number 16.
In item 16, your lordship. In last but one matter, I have a decision from the client, your lordship. I will note that effect.
You have?
In last but one item, WPC number 1995112.
What have you done?
I have no instruction, your lordship.
No instruction.
Okay.
First.
WPC 269 19951. All. Yes. What is the issue involved?
Here the issue is that they are all teachers of the aided educational institution. The revised scale of pay rules 1998 as per the recommendation of the 5th Pay Commission, that was made applicable only in respect of state government employees who are in whole-time employment of the state government. So far as the petitioners are concerned, they are all non-government aided educational institution teachers. Government took a decision to give them similar benefit as like the state government employees by virtue of a notification. That notification was made applicable from 2002, my lord. All that they claim that since it has been made applicable with respect to the state government employees from 1/1/1996, so the notification should be given a retrospective effect and they may be allowed the similar benefit from the date the state government employees have been allowed that benefit. That is the issue. But last date, my lord, in fact, he only appeared, but nobody else appeared for the petitioner. Probably they have lost interest.
And some early orders were passed linking a lot of places to be listed before the division bench.
Yes.
But those order cases which had been
Under the impression that virus of the statute is under challenge, but subsequently the last order passed by my lords, that is.
No, that was there. But before that, single benches have disposed of the connected application.
Yes.
About 12-15 cases were tagged. Out of them, 10 have been disposed of, I think.
There
Already.
is no representation on behalf of the petitioners. These applications are dismissed for default.
Those applications, 2025 and 2015. 2025 been disposed of, so representation can be
Item number 17.
Wait, please. Well, that 17 was inferior lordship's law. But it is a long checkered career, my lord. Regarding this, the petitioners are roadside vendors, my lord. My lord, they earlier came 2-3 times before your lordship's, my lord. The first time they came, it was decided to direct them, direct this once a municipality commissioner to give us some lands. Then they gave an affidavit that out of all the 77 petitioners, the 25 petitioners has been given. Then the Bhubaneswar municipality gave an assurance that they would construct adequate number of kisas on plot number 295 and allowed the same to all the petitioners. Then OJC 6483, I have prepared a small date chart, it will be helpful. Earlier it was given, my lord.
Yes, date chart is there.
May I submit, my lord? Lordship, the last date, Honorable Court directed the BMC and the state government to file a separate affidavit. That affidavit I filed on 8th. That is...
they have filed, my lord, but that doesn't solve my problem.
Yeah. As per that affidavit, Lordship, in fact, we have accepted one proposal that in the event, because the land is not available within a radius 10 kilometers, but we can accommodate in different places where the street vendor complexes has already been created. So that is what in my affidavit, Lordship, of a kind plans to. Yeah, that is para 7, my lord. Para 7 of the affidavit, we have made it clear. Pertinent to here that ascertain from the market section of the Bhubaneswar Municipal Corporation.
When did you file? Just a minute. Did you file
it? Was filed on 8th, my lord. 8th of August.
Filed on 8th, my lord, but your lord.
My lordship, the petitioner.
Affidavit is not there. Why it is?
In spite of pulling them up, they're not.
The BMC have filed the affidavit. But as per para 7 of my affidavit, my lord,
Mahapatra, that affidavit is not with us.
Record question.
No, record with I filed it in the court itself.
You filed it in court?
My lord.
Available achi record dekh le?
I filed it in court. And that is the reason, my lord, the petitioner made a prayer for filing rejoinder to that affidavit.
No, rejoinder not necessary. I have gone through the prayer because you told the problem has been sorted out. But going through paragraph 7, I don't find that problem has been sorted out.
It cannot be sorted out in a day.
No, that is right. But you mark, you.
This is old one.
Has your lordship got it?
Filed in court, my lord.
No.
Yes, my lord. I filed it and
in the registry, it is not there. And there is
no, my lord, in the court itself.
That you have filed it, there is no noting.
No, I haven't served with a copy.
I served a copy on him and filed it to court itself. Lordship, in fact, went through that and wanted what is left to be done. That is my remark, and petitioner wanted a rejoinder to that. That order sheet noting is something little bit problem.
Order sheet noting is he intends to file a
Little
counter
bit, yeah. That is the problem.
When we don't accept the counter affidavits in court and we ask them to file it in the registry, then such order is passed.
So
you have to ask your associate.
Okay, my lord. I'll I'll submit it and let it come to the next. In fact, we have agreed on principle. That's it. They are only to make application where some of them can be adjusted because there are vacancies existing in 9 of the locations. So in one place, all cannot be adjusted.
Learned senior counsel is on legs, so let us hear him.
Paragraph 7, I am only reading it out, what he is stating and what he has stated, my lord. This is the ingenuity of craftsmanship of a lawyer may land the petitioner in trouble, my lord. Paragraph 7, which they have stated, it is pertinent to mention here that it has been ascertained from the market section of Bhubaneswar Municipal Corporation there are ample shopping units available in different market complex. It is not in vending zone, but in market complex. Market complex of Bhubaneswar Municipal Corporation area. The Honorable Court may direct the petitioner to apply following due procedure for allotment of the units. Where is the undertaking that will be accommodated?
No, Mr. Mahanti, if I'm not mistaken, street vendors are not supposed to be given shops. They are supposed to be given areas where they can operate.
But it is there, some kiosks have been constructed.
Yes. Kiosks have been constructed.
So kiosks can be given to them.
Yes, ma'am. That is what we stated. That is what
they apply as per the norms.
Lordship have a kind glance to para 4.
We can assure you, we will not dispose of the writ petition because it relates to street vendors. All right. If some affidavit has been filed, tell your clients whether they can respond to that or not.
All right.
And if they are satisfied, then only we shall dispose of the writ petition.
Right.
So it is not that because of.
I understand. Otherwise, your lordship would not have asked them to file that affidavit.
Right. So
unless your lordship thought that it is important that the state government implements the act,
they'll have to.
Your lordship would not have asked them to file an affidavit.
Yes.
They have filed an affidavit that we have formed the committee. Then they have told we are thinking of giving it out to a third party for survey to find out who are the genuine vendors. So that will never end, my lord, that process. And my learned friend says that they have, in paragraph 7, I have read out, my lord. He says that the Honorable Court may direct them to apply following due procedure of rule of law. Then what about the...
No, you just approach. What all are they required to do, Mr.
My lord, they have to make an application. My lord, they have to make application to the Deputy Commissioner Vending. Deputy Commissioner Vending, who is in charge of the kiosks and shops. So, lordship, they can serially see the plan also, which place they required at least to be adjusted. Because all the 25 persons cannot be adjusted in one place. Different places.
That is fine. You don't accommodate, but give them something to live. That is all that I want.
They'll have to do. Just proceed on the basis of whatever has been stated.
But it is all vague, my lord. In that counter, they have not stated anything. They are according to the due procedure.
Where does Mr. Mahapatra reside? Where do you live? In Cuttack? Bhubaneswar. And these petitioners?
Bhubaneswar.
So they can go to, how many petitioners are there?
They have gone time and again I will go. No problem. I have been running to them from 1995, my lord. And they even admit in this affidavit that...
All right. So how many petitioners are there?
25. I've checked.
So give us a time and date when they shall approach the
Deputy Commissioner Vending.
Deputy Commissioner Vending.
Deputy.
All of them will go together.
Right.
All right. Just ask the Deputy Commissioner Vending to give them
to receive the
to guide them. All right. And to guide them how to resolve it. So when?
Lordship, any date may fix next week?
No, when should they go to your office? Not your office, Deputy Commissioner.
Deputy Commissioner's office, Any working day, my lord, so that accordingly I can instruct the deputy commissioner to be
Please
present.
instruct him at 4.
4.
At 4 p.m. All right.
Right.
It is stated by Mr. Mohapatra and counsel and senior counsel representing the Bhubaneswar Municipal Corporation that an affidavit has been filed pursuant to this court's order dated 8/8/2024. The said affidavit is not there on record. Stop. He has, however, submitted that there are slots available at different places in the town of Bhubaneswar.
Not plots, my lord, kiosks. Kiosks and shops.
Slots.
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 Yes.
Yes, it's slots. Spaces.
Yes.
Kiosks. Kiosks. Available in different parts of the city of Bhubaneswar, where these petitioners can be adjusted if they apply in accordance with the procedure prescribed. Stop. Next. Without prejudice to the rights and contentions raised in the present writ application on behalf of the parties, we adjourn the matter to, we permit the, we observe that let the petitioners approach the deputy commissioner vending.
Vending, my lord.
Commissioner
V.
vending Bhubaneswar.
Municipal commission.
My lord,
Bhubaneswar Municipal.
Bhubaneswar Municipal Corporation.
Bhubaneswar Municipal Corporation on which day? 1 week or second?
Next week, any date, my lord? 27, 28, 29.
At 4 p.m. in his office. So stop. It is observed that the deputy commissioner vending shall guide the petitioners and make them aware the procedure for making application for allotment of kiosks. So stop. List this matter on 2 weeks. So it will come after 2 weeks. In the meanwhile, you ask your clients to visit the office of the commissioner next week on Thursday.
Any particular date your lordship?
Date have we given? Thursday. 29th of August
Obliged.
at 4 p.m. They will go and he will guide. Affidavit, pleadings, if filed, be placed on record. Yes. What instruction are you getting, Mr. Monti?
My lord.
Any problem?
No.
Again, I was on my legs in the other court, another matter got adjourned also to the 29th itself. So,
What do you want? No, 29th, the matter has not been adjourned to 29th. The matter has been adjourned to
2 weeks thereafter.
September. 5th September.
29, the petitioners will go to the corporation.
Yes.
All right. So that you may tell the court on 6th what happened in the meantime.
But the interim order to continue.
Interim order shall continue.
Item number 18.
May I please, Lords? So this is the case of a lady lawyer, last time Lordship heard, who was in a peculiar way arrested, then incarcerated in the jail for 2 years, 3 months, 5 days, got acquitted on merit, not on the benefit of doubts, with the
Why the
finding.
matter was adjourned? Will you remember?
Yes, my lord. And
what can be done now?
Lord, 1610, state government said that we want to negotiate the matter outside the court. That was the order, my lord. 1610, I think.
Oh, no, all right.
So far as the compensation part is concerned, my lord,
No, but why the matter was adjourned here?
Mr. Adjournment, they want to negotiate. That was the order, my lord. If I remember it correctly, on the 1610, there was the order.
No, we were not satisfied. You wanted adjournment, it seems.
No, before that, my lord.
All right.
Before that, we were asking about the last date.
Oh, last date, your lordship heard the matter and fixed to today for further hearing.
Yes.
It was hard. It's not that.
We don't find any merit.
But here, my lord,
remember.
I have got a judgment. I have given the judgments, my lord. Bunch of judgment. Wherein even after acquittal, if the court came to the finding, the Supreme Court came to the finding that there is infringement of fundamental rights. One, by way of handcuffing, the other way, her picture was made in the publicized by help of the police.
When was that done?
My lord,
When was that done?
in this case, my lord.
Yes.
In this case, immediately day after she was arrested.
So you could have approached the court then.
My lord,
Why are you coming to this court after?
My lord, she was inside. My lord, she was inside.
Was she not produced before the magistrate?
Before the magistrate, my lord.
She complained.
My lord, their magistrate, she has not complained or it has not been noted, my lord. That's my lord. All those proceedings, he has not done. Now he has come only after she came out of the jail, my lord. She made a representation to the state government saying that the way she was taken to custody, he was interrogated throughout the night without presence of a police officer. No arrest memo was issued. And thereafter, in the trial, my lord, the trial court came to the finding prima facie there was no material to file the charge sheet, my lord. There was no material to file the charge sheet, and the organization, the allegation is that she is the convener of an organization, and that organization is not a banned organization. There is no overt act, no material against her. This is the case regarding now the allegation is that malicious prosecution. What was the prima facie material before the investigating authority to make arrest of a lady lawyer?
Please appreciate this. Everything was done under the judicial orders.
I say.
So you cannot say that you were in
judicial order
wrongful
after she was produced before the court, judicial order, my lord. Before that, she was interrogated. Before that, she was interrogated without in absence of a police officer in the night, throughout the night, my lord. And thereafter, my lord, the police has filed the charge sheet without prima facie materials. That was the finding of the court. And it is not in a benefit of doubt she is acquitted, my lord. All those materials could not prove that she belongs to a banned organization or her activity amounts to committing an offense, anything, my lord. And only after she came out, my lord, she approached this court invoking the public law, my lord. And the decisions, my lord, decisions I have given a lordship, given two sets of decisions, my lord.
Yes.
There they have given the scope where the court under Article 32 by the Supreme Court or 26 by the High Court, they can grant compensation. My lord. That was the decision, my lord, I have given with a written note of argument also.
Where is that?
My lord, that's there.
Which decision?
My lord, decision. One is S. Nambinaran, the scientist from Kerala, my lord. And that was the first and the decision which most applicable to me, my lord. The second one, that is Hardeep Singh, 2012, 51 OCR Supreme Court 205. Hardeep Singh, wherein after acquittal, now the court has given compensation.
Just a minute.
My lords.
Mr. Jenna, page 87. In view of my aforesaid discussions, I conclude that the prosecution has failed to bring home the charges under so and so against the accused persons beyond all reasonable doubt. Accordingly, I hold the accused persons not guilty.
Yes, ma'am. 57, madam.
Yes. 87.
87. Yes, that is the second case.
Second case.
Second case. In the first case, they say that
Where is it? Page? Annexure?
annexure, just the previous one.
Annexure 7.
7 million.
Okay.
Mr. You are relying on this, Nambi Narayanan.
Nambi Narayan, only for a reasonable, only for a particular.
Nambi Narayanan, in that case, the CBI had submitted a report.
Yes.
To the Chief Judicial Magistrate that the allegations against him were false.
Yes.
And thereafter he was discharged.
Yes, madam.
So that is the difference.
No, discharge, and thereafter the state government of Kerala again brought out another notification saying that the findings of the CBI is not correct. So that notification was again challenged, my lord. Then the Supreme Court came to the, he approached the court, my lord, and the Supreme Court interfered and saying that for a limited purpose, I rely on that decision. In what conditions, my lord, the court can grant compensation, my lord. 34 judgment, my lord, paragraph 34 of that judgment, my lord.
Yes.
Madam.
Nambi Narayan.
Yes, madam. 37, my lord. 37, paragraph 37, my lord. If the, can I read?
Yes.
If the obtaining factual mathematics is adjudged on the aforesaid principles and parameters, there can be no scintillating of doubt that the appellant, a successful scientist having national reputation, has been compelled to undergo immense humiliation.
All right, we will consider.
My lord. And the next one is relevant would be the Hardeep Singh case. Your lordship may note. In all other cases. Recently also, this Honorable Court granted 10 lakh, wherein Honorable Justice Ms. Savitri Rath was there. There also they dealt. Even though somebody is alleged to be a member of the banned organization, he cannot be treated differently.
Item 19.
Pardon, my lord. Item 16. I should have come that I was before lunch, I was all alone there in the court, but I did not feel well because of blood pressure.
Which item?
That back matter.
Item 16.
We'll take up that matter. All that.
We'll take it up. We are taking up the matter.
Item 16.
Argument କରନ୍ତୁ
କୁହନ୍ତୁ.
ଆଗକୁ କରନ୍ତୁ
All the cases. They have challenged the petitioner has challenged the.
So you are appearing in all the cases? Are you appearing in all the cases?
In almost all cases, I am there.
My lord, may I pray, my lord?
The counter
Can it be
has not
taken up on next Thursday?
Cases counter. has not
Next
been
Thursday may be taken up.
All right.
Because my
Connected
file,
matters have been disposed of, what I was
Yes, yes.
saying,
see, file would have,
by the single judge.
Well, accept that.
Tell Mr. Arun or somebody.
Item number 19. Item 19.
Nobody, item 19,
That's happened, nobody is appearing.
nobody from Mr. Rautrey's office, it is his,
I think,
must have become infructuous. Otherwise, I'm sure somebody would have attended.
Mr. Biswal was here only.
Yes.
So
What was the prayer? To lease out land for the petitioners association
yes, ma'am.
after 13 years.
And their allegation is that those lands have been also, they say that these are all ceiling surplus lands. Those should be leased out in their favor, not. But in
Why?
they say because they are landless persons belonging to the not so
No,
those strata.
it is an association.
Yeah, association, they said their members,
Association of landless persons.
they say that.
There is no representation on behalf of the petitioner despite repeated calls. The application is dismissed for default accordingly.
Item number 20. May I please, Your Lordships?
As requested on behalf of the opposite parties, is this matter on 2 weeks?
Well, the 29th, Your Lordship, because 2012 matters, the sewage and drainage matter has not been supplied to the block. For that matter, since 2012.
He is suffering from dengue.
My lord, that's next, Your Lordship may say 29th. 2 weeks, my lord.
2 weeks?
29th, Your Lordship.
He may not come.
Item 21.
My lord, annexure 3 is under challenge, my lord.
What is?
Annexure 3 under at first 36, my lord, that is passed by the Honored DRT Cutter, wherein my petition to set aside the ex-parte order has been rejected.
No, where is the order?
Annexure 3 at page 36, lords. Yes.
Annexure 3 is not an order. Annexure 3 is an order. All right, 38. Yes.
Yes, my lord. My petition has been rejected by the Honored DRT, my lord. I have filed 2 petitions. One petition for condonation of delay, and that has been allowed. Whereas there are no sufficient grounds as has been held by the Honored DRT. My petition to set aside the ex-parte order has been rejected, my lord. By profession, my lord, petitioner is an engineer, my lord, and residing outside the Odisha throughout his career, my lord. And what happens in this case, my lord? The bank has filed 2 sets of original application before the Honored DRT, and OA number 368 of 2009 that has been filed by the bank. That OA has been dismissed because the signature of the petitioner has been first, my lord, and by the help of fake documents, my lord, the bank officials and the opposite party number 3, who has been added as a loanee in this case, my lord, they have tactfully obtained the loan amount, entire loan amount, my lord. Well, in this case, my lord, the OP number 3, which is Manoj Pradhan, he has been added as a loanee. And in the earlier application of the bank, which has been dismissed by the DRT, the said person Manoj Pradhan, who has the guarantor, my lord. And the grounds which has been stated by the DRT, my lord, while dismissing my petition, that the contents of the petitioner is disbelieved, my lord. I have also deposited rupees 2 lakhs before this honorable court, and the interim protection has been granted by this honorable court. It is a case of forgery, my lord. I have never signed any document, neither the guarantee covering letter, my lord, as also any other document of the bank, my lord. And throughout my career, I am outside the state. That is also held by the tribunal in another case, my lord.
Have you given a police complaint after knowing
Yes,
about
yes.
this forgery?
That is annexure 1 is the total order sheet of the criminal case, my lord. Entire order sheet.
Who is for the other side?
My appeal provision is there. Again, they should approach the DRIT matter under section 20.
Why didn't you file appeal?
Because this honorable court has also jurisdiction, in spite alternative remedies available.
Then that tribunal can be closed.
The case of forgery, my lord. And every document has been
Forgery we
false.
cannot hold. That's a case of forgery. But if your submission we accept, then we can direct foreclosure of the appellate tribunal. Because we are the appellate tribunal. Every case, because the alternative is not, remedy is not a bar. Therefore, everyone should come to the High Court. Why should one go to the circle officer or bank manager or? We can do everything.
It's a case of
We can
2012.
correct your passbook. We can see that whether your checkbooks are properly maintained or not.
It's a case of 2012, my lord. I have also deposited rupees 2 lakhs before this honorable.
You cannot dismiss this. Yes, so this is the only case is that notice was not served upon him.
My lord.
So that he has been able to make out a case. That notice was not served upon him. Adjournment counsel appearing on behalf of the petitioner and learned counsel representing the bank. Representing the bank. The petitioner, in the present rate application has put to challenge an order dated 8/11/2011 passed by the presiding officer Debt Recovery Tribunal, Cuttack, Bench, Cuttack, whereby the petitioner's application for setting aside an ex-parte order dated 10/7/2008 in OA number 51 of 2008 has been dismissed. First off, the petitioner you were opposite party member in the before the tribunal?
2, madam. Bank is 2.
2.
It has mainly been dismissed because of the delay in filing the application.
No, delay petition has been allowed.
Yeah.
The notice was served, but they are, as per their area, they are not present in the house. He is staying outside the paper publication was also made.
The petitioner was arraigned as defendant number 2 in OA number
51 of 2000. 51 of 2008.
51 of 2008. Where is that order? Passed in order dated 10/7/2008.
Annexure 3 you will see. That's
No, not annexure 3.
10/7.
Not 10/7. 10/7. The order.
Original order. The original order where the order has been passed against you. Have you annexed that?
yes, Annexure 3 is the.
No, annexure 3 is the impugned order.
No, original order.
Okay. I think you have not given that order, have you? No, that order is not there.
Sorry. One of 2008. What was the order passed in that case?
There are 10/7/2008 passed in OA number 51 of
What is
2008.
that order? Where?
Original order.
Where is it?
No, they are not annexed.
Do you have a copy of the
No,
order?
So what was the order?
that order, the ex-parte order was passed declaring the against the defendant 1 and 2 and for the RP mallots.
Is it quoted anywhere?
They have not also quoted.
No. So you want us to pass
Let us say an order.
this judgment in abstract? Yeah.
Challenge that order, you should file the copy.
Do you have a copy?
Wait, my lord. Oh, sorry.
Bring that order.
Yes, sir.
Which was filed by the Canara Bank seeking recovery of sum of rupees 20,52,837 with interest. the same was allowed ex parte by an order dated what is the order, ex parte order dated?
10/7/2008, madam.
10/7/2008. In the absence of the petitioner. Stop. In the said background, the petitioner filed an application before the Debt Recovery Tribunal for setting aside the ex parte order on the ground that the notice was not served upon him. So stop. The petitioner took specific plea in his miscellaneous application, that is MA number 121 of 2010. Convolution. MA number 121 of 2010 with an application for condonation of delay. The delay was condoned by the presiding officer by an order dated 8/11/2011. But the application for setting aside the ex parte order came to be dismissed by an order passed on the same date. So stop. Next. When counsel appearing on behalf of the petitioner has argued that the petitioner was able to demonstrate before the tribunal about non-service of notice. The tribunal, however, declined to set aside the ex parte order without duly considering the petitioner's statement. How has the presiding officer held that you avoided to appear despite you had sufficient knowledge? Page
44, my lord.
What?
Of the.
Of the order, my lord. Annex 3, my lord.
What?
that now coming to the present case, the registered envelope sent to the applicant was deemed to have been served on the applicant, and the presumption can be drawn that the addressee has received the notice sent by the register post. However, the presumption is rebuttable on
Rebuttable.
constitution of evidence in
Impeccable character.
character. Man to believe that a case has been filed against a person and the postman is
Petitioner's statement. Drawing presumption about service of notice on the address, service of notice through registered post on the address, petitioner's address, as mentioned in the original application. Stop. Next, we have perused the counsel representing the bank has argued that the petitioner has alternative remedy of appeal against the order impugned, which he has not availed. Stop. He has further submitted that the impugned order suffers from no legal infirmity requiring this court's interference, exercising power of judicial review. Stop. Next, we have carefully perused the impugned order passed by the learned presiding officer rejecting the petitioner's application for setting aside the ex parte order. So stop. We are not inclined to entertain the submission advanced on behalf of the respondent bank, opposite party bank, that this court should dismiss the application on the ground of availability of alternative remedy, for the reason that this application has remained pending before this court for 12 years. Stop. Next, upon perusal of the impugned order, we find that mainly on the ground of presumption of service of notice through registered post, the learned presiding officer has reached a conclusion about due service of notice upon the petitioner. First off, it was specific case of the petitioner that he did not live in Odisha.
Outside Odisha. Now he is living in Malad, Gujarat.
No, at that time.
At the time he was in Lucknow, UP.
He was not residing in Odisha when Odisha, and a wrong address was mentioned according to you.
No, address is, but that is under lock and key. He is staying outside. He was staying outside Odisha.
But the presiding officer says your mother was there, you must have gone to visit.
Some occasions mother came to, and his mother also going to other children.
The presiding officer also noticed that the petitioner's mother was residing at the address given in the original application on which the notice was sent, and therefore the petitioner must have had the knowledge about dependency of the case. So stop. Next. After having perused the impugned order, we are of the considered view that the finding recorded by the presiding officer that the petitioner had the knowledge about the pendency of the original petitioner shall be at liberty to file his objection in original application. Original application. And consequently, the ex parte order dated so and so is also set aside. The petitioner is directed to appear before the tribunal by tribunal within 4 weeks from today and file written statement or what?
Written statement.
And file his written statement, whereupon the original application, OA number so and so, shall be decided on merit in accordance with law by the tribunal. Yes.
Let us small, that MA 120 is for the limitation and MA 121 is for the. ex parte.
121 we have said.
121 was mentioned.
121 is for the ex parte order.
Yes, yes.
Yes, ma'am.
Item 22.
To Ms. Patnaik, is anything surviving in this? Because the opposite party is also not there.
Not there. It was on the last occasion, what the order sheet says that it was supposed to be moved to the Lok Adalat.
No, but what is the relief claimed for? What is the
It's
relief
come
claimed
for an OTS proposal, Your Lordship.
Bank.
No, the petitioner.
No, OTS is one-time settlement, if I understand.
Yes, Your Lordship.
So that has to be either with the bank or finance company.
It's with the bank, Urban Cooperative Bank, Your Lordship.
Bank is also not here.
Not
Which, item 22?
22.
But that is against Punna Chandra Satpathy. That can't be the bank.
It's actually, he has come with the manager of bank.
Bank.
No, 22 is versus
But who is this Punna Chandra Satpathy? Bank manager?
bank manager of Urban Cooperative Bank, Your Lordship.
In person. Everybody in person.
That's a petitioner also in person.
No. I mean, completed person, bank officers. So and so branch manager.
No.
So and so clerk.
First.
Huh.
Yes.
Item 23.
20.
23.
With mentioning that Sanjit Mohanty, senior counsel, London senior counsel, will first today.
Next Thursday?
In the week commencing from 9th of September.
All right. Thursday next. As requested on behalf of the petitioner, list this matter on. Yes.
Item 25.
In this case, the petitioner was awarded with a transportation contract for coal from stockyard to coal handling plants of MCL. Total quantity of coal that was supposed to be transferred from this point stockyard to is 22 lakhs ton, and the period of contract was for 3 years. However, and the per day limit to raise coal was 2,110 tons per day. It was subsequently raised to 6,000 tons per day. as the quantity increased, that there was short lifting of coal, and the opposite parties, as there was short lifting of coal, they terminated the contract of the petitioner. And what they have done after terminating, they have encashed the performance security, forfeited the performance security.
So any arbitration clause in the contract?
No, my lord, there is no arbitration clause.
So we are required to decide.
Yes, sir.
Why should we decide such disputes?
My lord, the only question here is that they have alleged a breach, and they accordingly they have adjudicated the same.
So you could have filed a suit.
But here they have already forfeited the security amount.
Yes.
They have alleged the breach themselves, and they have adjudicated the matter, and they have said that we are at fault. But the dispute is that the both parties are saying that they are not at fault.
You want refund of that performance security?
Yes.
Who is for the other side? Where is the agreement?
Agreement that has not been annexed.
Not annexed.
You have not annexed, then what for? Without agreement, you want us to adjudicate.
The NIT notice inviting tender.
Huh?
Notice inviting tender is there.
Where is that?
Annex 1.
purchase.
Yes, is there any arbitration clause in the contract, sir?
No, sir. There is no arbitration clause.
You are for whom?
The party.
I am for the opposite.
There is no arbitration clause in the contract, sir.
Gentlemen appearing online.
You are for who? You are the party.
Yes, sir.
Please sit.
Ajay Transport Company.
You are appearing for him.
Yes, Your Lordship.
Because
Okay.
the council is appearing, so decide who will appear.
So there is no arbitration clause in the agreement.
Where is the agreement?
Agreement is there in the plan. Is in the.
Matters relating to dispute or difference will be subject to jurisdiction of district court.
Where is
So
it?
MCL has itself given a revised approval letter.
Page?
51. Old contracts or what? Last 40. Page 31, serial 40. Clause.
Come to page 31,
Yes,
clause
sir.
40.
Yes,
You could have filed suit.
But Your Lordship, here they have already encashed the bank guarantee since 2011.
You could have done that. Who stopped you? Not now.
Sir, we have waited for last 12 years.
Is there any interim order? Nothing? It has already been encashed a question of interim order. Sir.
Sir, we have been waiting from last 12 years to get justice.
You should have gone before the appropriate forum, Mr.
Sir, after waiting for so many years. The company itself has given a revised approval order in which they have only restricted our penalty to 37,000 rupees, whereas they have encashed a bank guarantee of 9,11,000 rupees from us.
You have been waiting for last 12 years.
Yes, sir.
And we have been waiting for you. The matter was listed on 16/8/2018. At
Right.
your instance, the matter was adjourned. Thereafter, the matter was taken up on 3/9/18, 10/9/18. You were not appearing. 17/9/18, no one was appearing. And you are blaming the institution.
No, sir, we are not blaming. That's why I have come myself today, sir.
The
how can we entertain? The file so can give that liberty. Otherwise, it is very difficult for us to decide. We can take evidence.
What is your stand? In
Sir,
your affidavit?
As Counterfeit have said that their allegation of their plea that because of there was some problem in the CSP, coal handling plant, and there is shortage of stocks. That allegation because of short supply, shortfall in transport, they are attributed to two reasons. One thing they are saying that there is not adequate coal stock.
What is the submission is making that you have penalty you have reduced to 36,000 or something?
Yes, madam.
That I don't know where he's saying. I don't have any information that.
Is that part of the record?
Yes, sir. They have reduced
Submission is
it
making that they have subsequently reduced.
to 37,506 only. Sir, what they are saying about availability of coal, we have been continuously writing to them that there is no coal. If they are saying that there was coal, they should have gone for a joint verification meeting. I told them several times to go for a joint verification meeting and show me where is the coal. They themselves have signed the hindrance register, for which hindrances the work could not be completed, that the company has signed it, and they have not put any penalty on us. Neither they have terminated the contract.
Mr. Modi.
Sir.
First of all, you withdraw your wakalatnama.
Sir.
And please don't interject during the course of hearing. This is not the way. You seek permission first.
Sorry, sir.
Do you hold wakalatnama on his behalf?
Yes, sir.
And you return it.
What is your name?
Prayas Manti. P. Manti.
List this matter on 1 week. Stop. The petitioner wants to address this court in person. Since the petitioner wants to address this court in person, online.
It will be taken up after 1 week. Since you want to argue the case yourself, please do that on the next date. All right?
Okay, madam.
Item 37.
On my mention being made today morning, they served a copy of the counter on me. I've gone through the counter. No rejoinder is necessary. I'm ready. But my learned friend says that the counsel who is to argue on behalf of the state is not available today. So may I pray your lordship may take it up on Tuesday at a time fixed by your lordships?
Tuesday.
Lordship, we are depositing the costs that
Tuesday, your lord,
They can, here will take and it will not be available again. The counter is there. Giving that cash receipt and everything, the counter is a better. Give it there because you see papers are sometimes getting misplaced. So better you give it in the counter and take a receipt.
can it be taken up
You have
Tuesday?
filed your affidavit.
yes, your lordship.
A counter affidavit has been filed on behalf of the state today. Copy of which has been served upon learned counsel for the petitioners. So stop this the matter on Tuesday.
Cost has been paid today also. Cost
Yes, your lordship.
20,000, how much?
20,000.
It is noted that we have been informed that cost of rupees 20,000, which was directed to be paid as condition precedent for filing of the counter affidavit, has been paid in the account of
Advocates Welfare Fund.
Yes, your
Orissa High Court, please give the
High Court Bar Association, your lordship.
High Court Bar Association.
how many associations are there?
High Court Bar Association, the Welfare Fund heading or only that?
Only the High Court Bar Association, your lordship.
No, they give the receipt in the name of the High Court Bar
It's a
Association.
welfare fund.
but
It
the
goes to the welfare.
Amount goes to the welfare fund now.
Receipt says it's only the High Court Bar Association, but the amount will be deposited in the welfare fund.
What was our order?
It's welfare fund.
Our order was to before the welfare fund.
Yes, as directed, then we can say.
Lordship on Tuesday at 2 p.m. Lovely.
Tuesday और बहुत 2 PM थे वहाँ.
Okay.
2 PM there must be 5-6 matters. Achi, note question.
Tuesday, let it remain where it is. We will take up your matter.
Lovely.
Just make a mention as we have taken up your matter today.
Lovely.
One misplaced or this they get to do it there.
Let the file that in the registry, madam.
Yes, your lordship.
Counter also, counter भी दे दें.
Counter they are filing, e-filing.
এটা খালি extra দেবে কি? E-filing টা আসুন. Okay, very good, very good.
Item 27. $27.
No one appears. Discussed.
Item 28.
Take please, Your Lordship.
But this is a matter in which, my lord, this is a lady entrepreneur who was allotted with a petrol pump. And in a running petrol pump, my lord, due to altercation with an officer of the CBI, a series of attacks were launched on me, my lord. My lord, I wish to point out, my lord, I see from the list that the CBI has filed its reply.
What is the relief which you are seeking?
My lord, I am seeking quashing of the show cause notice which was given to me.
Show cause has been issued by the opposite party 1 and 2. That is the oil corporation. He is a dealer under me. So on the nature of the CBI, that there were certain irregularities and a criminal case has been launched against him, I had issued him a show cause notice. And he has not responded to the show cause
No,
notice.
he is challenging what? Where is?
He is challenging
My lord,
the show
I am
cause notice
challenging
Annexure 6.
Annexure 6 at page 31 of your lordship's brief. And the ground of challenge, my lord, is that this
entire show cause, my lord, is at the behest of the CBI.
No, sorry. Have you responded?
My lord, I have come saying that the show cause is premeditated, my lord.
We cannot go into
My
that.
lord, may I just submit that opposite party 2, 3, 4 have filed the reply, my lord, and I have not received a copy. 3, 4, and 5 is the CBI. They have not. I have not served me a copy. That's number one. Number two, my lord, I have impleaded as OP number 6 the person at whose behest all this prosecution has been launched against me. No reply.
If we cause the notice,
my lord,
then we will have to cause the criminal case also.
No, my lord, not at all. The criminal case, my lord.
Sorry, we will not do that.
My lord, the criminal case, my lord, has no nexus with this proceeding, my lord.
All right.
This is for termination of my dealership. Criminal proceeding, my lord, lordship will kindly.
So you could have responded to this so-called notice.
My lord, the situation in 2012 was very, very
now we are in 2024.
My lord, may I only pray, my lord, let the respondent 3, 4, 5 supply me a copy of the counter affidavit they have filed.
Which counter affidavit?
My lord, 3, 4, and 5. That is.
Are they relying on that?
My lord, 3, 4, and 5.
Mister, are they relying on the content on the contents of the affidavit in their so-called notice?
Yes. The entire show cause notice says on an information supply. I'll take your lordship to the show cause notice.
Yes.
Page 31.
So you see the documents which you require for filing your reply.
My lord, kindly see the conclusion. I'll just place the show cause notice. My lord, Oryx Fisheries directly hits this show cause notice. My lord, page 31. I'm conscious, my lord, normally lordship is not inclined to interfere in show cause notice matters.
Yes.
Kindly take 31 for a minute, my lord.
Yes.
And permit me to place 31.
Yes.
Page 31, annexure 6, my lord. This is dated 7/7/2012. Prior to that, my lord, in the sequence of events, may I seek your lordship indulgence to rely on 3 documents which are annexed prior to that.
We will not see any other document except for this
Very well.
so-called notice.
Very well, my lord. Kindly see the show cause notice at page 31, my lord, for a moment.
Yes.
May I just place the second para?
Yes.
We have been informed by the CBI SPE Bhubaneswar that a case bearing number such and such has been registered on 21/3/2011 in CBI SPE Bhubaneswar against you, wherein it was alleged that you have been awarded dealership in illegal manner without any public interest, and that you suppress material facts and furnish the information forged documents in respect of your work experience, and that you have submitted false affidavit in the names of non-existing persons to show exaggerated sales potentiality of the proposed retail outlet. What they mean to say is, my lord, the projected retail sale should have been 100. It is actually not 100.
You could have said this is wrong.
My lord, kindly see what they say. Kindly see what they say in the subsequent paragraph. We have received a self-contained note dated 12/5/2012 from the CBI SPE Bhubaneswar stating that the findings of the CBI in the investigation carried out with regard to case number such and such. From the findings of the CBI in the investigation carried out with regard to the case registered against you on the basis of source information received at them, we hereby inform you the following on perusal of the findings of the CBI self-contained note. My lord, this is not part of an investigation under the Delhi Police Establishment Act.
See, you could have asked them whatever document. If you wanted some document, you wanted some information for replying to. If you did not have any information, you could have denied.
The show cause prima facie, my lord, no case is made out.
Then you tell them.
That is
no
why,
case
my
is made
lord,
out.
today, even in the criminal prosecution, no charge sheet is filed despite 12 years.
See how fair is the investigation, how fair the CBI people are, that despite the fact that the FIR was registered in 2012, no charge sheet has been submitted.
No case made out, my
No
lord.
case made out.
My lord, what happened actually? My lord, what
unnecessary wasting the court's time.
Not at all, my lord. May I seek your lordship's indulgence, my lord? Let them supply me a copy. Lordship has the matter.
Copy?
The counter affidavit they have filed justifying this action. It's a counter affidavit. My lord, the CBI has filed a counter affidavit.
Where?
In this court.
The CBI was not required to file counter affidavit.
They have filed and they have not supplied
Not
me a
required.
copy. The entire, my lord, if your lordship takes the annexure.
Sorry.
Kindly see the annexure for a minute, my lord. Just kindly permit me to place the annexure. The complaint, page 23, where it emanated from. It's an ego issue with an CBI officer. Please see page 23. I am a lady entrepreneur, my lord. And there is no allegation. Neither is there an allegation that the high-speed diesel or petrol supplied by me is fabricated, is spurious. Kindly see, let me place the document, then your lordship may decide as your lordship pleases, my lord. Page 23 for a moment. Kindly.
Then we will decide.
My lord, permit me to place it.
Then we will decide.
My lord, please permit me to place
Yes, we will permit you and then we will decide.
My lord,
argue.
My lord, then may I say, my lord, that lordship permits me to file a reply to the show
We
cause,
don't know.
but protecting me, my lord.
No, we will
Because,
not.
my lord,
We will consider all your submissions and decide.
My lord, the agreement with Hindustan Petroleum was of 2006, valid for 30 years, my lord. Every 15 years, they renew the agreement. Despite the situation, 2021, Hindustan Petroleum has renewed my agreement. And I am a star performer for Hindustan Petroleum. My lord, this was the case wherein an inspector of CBI came and told a vending boy to fill in 3 liters of petrol. Now, while he started dispensing the petrol, this gentleman, OP number 6, who is named here in my lord, said, no, stop the petrol. Now put XYZ amount of money worth of petrol. The vending boy said, sir, I cannot do that, which led to an altercation. Kindly see, that is the complaint he has registered against me at page 23. In response thereto, my lord, at 24, I have given my comments that the dispensation of the petrol had started. Nevertheless, I stopped it. The CBI officer didn't pay for it. Forget about all that, my lord. Then the comment of the Hindustan Petroleum is, please go and apologize, write a letter to the CBI officer. Page 25, I have issued an apology on the very same day. Kindly see the sequence of events, my lord. This is not a case of spurious sale of petrol or diesel, my lord. This doesn't attract the provisions of the Motor Spirit Sale Act, my lord, neither the provisions of the lease agreement. My lord, this was an issue of an ego clash with a CBI officer and a heated CBI officer getting after me, my lord. I have never had any, I have an unblemished supply record.
Just a minute, Mr. Mukherjee, that complaint says that he was rude to the customer.
Sorry, Malak?
That complaint at page 23.
Yes, Malak.
He says,
as the customer, his behavior to the customer is rude and not courteous. Being aggrieved, I lodge a complaint. This is the complaint of OP number 6. This is the foundation of this entire prosecution against me.
That, my lord,
And
that is
show cause.
with an individual. I do not know what he has, what issues that, as far as the individual is there, and what is the issue with the CBI. The CBI has made certain allegations, which are very serious in nature and which directly impacts the dealership. If somebody takes my dealership on the basis of forged documents, I obviously have to take that into consideration, and I cannot ignore them. The CBI tells me that A, B, C, D documents.
Let him complete, otherwise.
My lord, may I just pray that let the CBI's counter come into my hands, my lord, so that I am able to assist your lordships in replying.
CBI is not appearing, so we can't direct.
They have filed a counter, my lord, lordship sees the...
Not required. We will not consider the counter affidavit. We will not refer to...
My lord, then, my lord, if your lordship's view is, my lord, I should go and reply to the show.
No, we will
kindly protect me, my lord.
We are not forming. See, if you have decided to argue,
No, my lord,
please.
my lord.
We also have a duty to answer all your submissions. We will consider.
My lord, had this been a case wherein, my lord, the Motor Spirit Act was attracted, my lord, or a case of spurious liquor, etc. Because, my lord, lordship will see I have annexed, my lord, they have raided my premise also. And that, my lord, the raid report is at page 26. My lordship may kindly see the raid report. Then, my lord, may I take your lordship through the sequence of events, my lord?
Yes.
Page 23, my lord, is the complaint lodged against me. I'll attempt to persuade your lordship, my lord, because this is a gross case of abuse of power in the hands of the CBI, my lord. That officer may not be there today, my lord, but I am suffering this show cause notice, my lord. Kindly see page 23 for a moment. Annexure 2, my lord. I do not intend to waste your lordship time, my lord, but here is a case of gross abuse of power in the hands of an officer holding a high position of power. And I am a lady entrepreneur. Kindly see 23, my lord, annexure 2. This is lodged by Mr. J.N. Rana, who is OP number 6. He lives in the CBI colony, my lord. I took petrol from the pump today, wide cash memo such and such, and asked the person delivering the petrol to give me the preset mode, but he refused to do so, even though machine was in order. I asked the owner, apparently present in the petrol pump, as to why this was done. He refused to listen to the complaint, for which I have lodged this complaint. His behavior to the customer is rude and not courteous. Being aggrieved, I lodged this complaint for appropriate action. Signed by Mr. Rana. The next page, my lord. I have responded to that, saying that, page 24, my lord. Customer Mr. J.N. Rana told the delivery boy to deliver 3 liters of petrol. After delivery of 6 rupees, this customer said, give me petrol with the preset amount. Then this boy gave the petrol by feeding the delivery amount. The customer used bad language for the boys. In the meantime, dealer's husband came to the pump to apologize, and when he left the pump, threatening the dealer's husband. And on the right side of page 24, my lord, the Hindustan Petroleum advised me to apologize in writing to the customer. That this is on 28/5/2010, my lord. Next page, page 25.
So page 25, second last paragraph.
My lord.
And could attend you or could not attend you?
My lord, I apologize once again for the unpleasant. I assure you that the same would never be repeated again. I request you to kindly continue your patronage and also your valued suggestions. This is signed by the petitioner herself, my lord. Second para, I wish to assure you that it has always been my objective to serve my esteemed customers in the best manner, and therefore I'm extremely sorry for the rude behavior of my staff. I have already taken corrective action to ensure that all my delivery men will deliver through the preset mechanism only. My husband has visited the outlet to take the cash to deposit in the bank for the RTGS payment, and since 3 p.m. is the deadline, it was fast approaching, he had to rush and could not attend to you properly.
I asked you that question, you read the whole.
I'm very sorry, my lord. It could not attend to you properly with proper courtesy.
No, what I understand, it may have started because of some tiff with the CBI officer.
My lord.
But what they have investigated and asked you to reply, what is the problem in replying to it?
My lord, kindly.
They said you have given some fake documents and fake statements of non-existent persons.
My lord.
If that is not true, if you give a show cause reply, that can be attended to.
I shall file the show cause
Exactly.
reply.
Then what
I'll file the
we
show.
can't go into all those things.
I'll
here.
file the show cause reply. I'll file the show cause reply. Lordship permits me a reasonable time. I'll file the show cause reply and appear before them, my lord.
As you wish.
I leave it to your lordship, my lord, because this is a case of gross abuse of power. That's a lady.
Lots of you don't repeat so many
You are
times.
leaving to
Very
the
well.
court in court.
I'll file the show cause reply. Lordship may give me that liberty.
The petitioner, after some argument, seeks permission to withdraw this writ application with the liberty to reply to the so-called notice dated 7/7/2012, which has been put to challenge in the present writ application. So the writ application stands disposed of accordingly with a liberty to the petitioner to file his reply within 4 weeks from today.
As a lordship.
Stop. If he does so, it is expected that the competent authority shall take a decision within 2 months, thereafter. So stop. We have taken note of the fact that there is an interim order passed by this court saying
For the proceeding.
staying further proceedings in the matter arising out of in the matter subsequent to issuance of so-called notice. Full stop. The that there is an interim order passed on 25/7/2012, whereby the said so-called notice dated 7/7/2012 was for proceeding pursuant to. There is no proceeding whereby the proceeding pursuant to the later dated 7/7/2012 was directed to be stayed till further orders. Stop. This is the reason why we have extended the period for the petitioner to respond to the so-called notice by the present order. So this application stands disposed of accordingly. We make it clear that we have not entered into the merits and merits of the case and the issues raised in the presented application, which the petitioner shall be at liberty to raise before appropriate authorities less forum.
Deeply. Item number 29.
But so may kindly see the order number 31. That is order dated 18/4. Particularly paragraph number 4, my lord.
Order number?
Order number 31, my lord. Dated 18/4. 18/4/24, my lord.
Yes.
My lord. My lord, this is a case, my lord, where since 1961, my lord, the land has been taken by the state. And state has admitted, my lord, in the counter affidavit and my lord, additional affidavit that this land has never been acquired. So your lordship has directed them on the order number 31 that state shall be under obligation to inform this court about its further proposed course of action, my lord.
Yes.
Yes. Pursuant to Lordship direction, Lords, the Department of Lords, but the Revenue Disaster Management was directed the collector, because the collector is the authority to issue the notification, Lords, to take the appropriate action. And in the meantime, on 1/7/2024, the collector directed the Lords, sub-collector to demarcate the land and found out, because it's a big patch of land. The allegations of more than 5 acres of land has been Lords in possession of the state. So now they want that on which part of the land they have constructed the quarters and offices, and rest of the land they may not acquire if it is not on the separate side, because if it is in between.
So after you demarcate, you will decide which you should acquire and which you should leave.
That notification will give. If you also can grant some time, because these orders I have already got, grant some time, we will go for the notification.
Only issue is, my lord, lordship, after this order, my lord, the particular order, my lord, which as lordship has seen, after this lordship has given them already 4 months time. On 2 occasions, 2 months and 2 months time. Lord, and this is a 61 years we are dealing with, my lord. And this is the second generation.
Your writ petition is pending for last 12 years.
12 years, my lord. And
it is because of this order passed in 2004, 24, that something has
exactly,
happened.
my lord.
Let
And
us hope.
out of this 33 orders, my lord, till today, my lord, 22nd time. This is the 22nd time, my lord, the state is taking time.
All right.
Lord, may kindly consider that.
To entertain the after so many years,
As requested on behalf of the state, list this matter on 4 weeks to be 4 weeks in first 5 cases.
Item number 30.
Item 30 on behalf of Ms. Mahapatra, my lord, he is suffering from fever, my lord. I pray this matter will be taken up next week.
These have already been granted to the client.
All right. The relief has been granted.
Then about 2 lakhs been paid to her.
Let it come next week, my lord.
I have already paid everything.
As requested on behalf of the petitioner, list this matter on 1 week.
I'm giving you the evidence of payment.
We can note that also.
And senior counsel appearing on behalf of the Kendriya Vidyalaya Sangathan has submitted that the petitioner's grievance has been redressed in the independency of the application. Also,
You inform her so that next week we will.
But the instruction on that, I'm giving the orders
Yes,
of
that
payment,
is
etc. given to her.
Item 31.
behalf of senior advocate Praful Kumar Ratan was taken up next week.
A school matter.
31 your lordship. MIQ skewed myself.
What do you want?
Taken up next week your lordship.
Why?
They held up in another court.
That to go with which matter is this?
Is that school?
Admission? No.
No, I think facilities are provided
Yes,
to the
yes,
schools.
yes, ma'am.
Were you supposed to file any affidavit?
Yes,
You
I have
complained.
already filed an affidavit on 8th August.
Let us see if it is there. Our office takes 1 month to get affidavits on record. Let us see.
Let me see my affidavit dated 8th August.
Let us see. Was it listed?
Not there.
Was it listed after 8th August? No.
No, ma'am. Yes, ma'am, it was listed but did not reach the last occasion.
Okay, let us see. Let us.
वो जरा बताना कि नहीं reach होता पता करो. Why they are not being placed?
E-filing is done so that it can be done and they are not like. 7th, yes, that is there on record.
Affidavit on 7th, it
Yes,
was filed on 8th
record.
August.
It is there on.
Yes, proper bookmarking has not been done, giving the date, but it is there. It is there.
Yes, ma'am. It contains 958 pages.
Yes, dated 7th, 8th, so it must be that.
Affidavit on 7th, 8th, filed on 8th.
Yes, there.
As per my lord's direction, we have prepared a chart and out of lord's we can get it from para 5 of my affidavit.
If we pass over, can he come or?
See, the message is going on since
Okay.
last 20 minutes.
On index.
We'll list this matter on, as requested on behalf of the petitioner, list this matter on next Thursday. Is there any?
Just a picture of senior counsel. Amicus curiae.
Oh, that matter.
Ma'am.
Is there any progress?
Yes, ma'am. There is progress, ma'am. Out of 44,000, now the data is in respect of 23,000. 24,623. We have given the data and the details. And also a committee is formed how to collect the data. Every month a review meeting will be held.
Substantial progress.
Better.
No.
Yes.
So I'll take another
Wednesday.
Wednesday.
Next week, Wednesday. Okay. Okay. Right.
Case admission item 32.
32 pursuant to lordship direction, I've received the original records in yours. I will hand it over to lordship.
This is that case where that objection had not been
Yes.
discussed.
That was the allegation that no objection was filed. Therefore, the lordship wanted them to produce the records.
Yes.
Objection was there. I flag marked the
That will digitize. It will fall into pieces very soon. Objection is there.
and that is also a finding by the learned nurse revisional court at page 61 of the brief.
Seen, I pointed
Yes.
out that.
So that is it there. Lordship can.
No, I think this relates to the original objection, not here.
Before this one will go.
No, relates to original.
Oh, original objection before the sealing authorities. Sealing authorities.
So there probably had not given. In that case, she has given. If I am not mistaken, because this was there long back, let us see. Learned single judge said that there is no objection.
Yes.
Sir, honorable
There
civil
is no
judge
filing of
stated-
objection by the petitioner and also said that in the impugned orders, no such reference is there. But
In
both-
order, there was a reference.
there are references and objection was also filed.
Counter affidavit, there was a reference.
Yes, yes, in the counter affidavit also they have stated the date.
You have a copy of the objection?
I didn't have, that is why your lawsuits have called.
No,
for.
no, no, because this is going to fall into pieces very soon. That is why I'm saying.
I don't have.
A certified copy.
Yes.
Sir, they have produced, flower, it has been scanned.
Whether any counter affidavit was filed in this case?
No, in the writ petition counter.
Original writ petition counter affidavit was filed.
So what was said about the objection?
Not at paragraph page 61 also may kindly look at. That is the affidavit filed by the state. There it is stated, it is humbly submitted with that in her petition dated 28/8/74. That is the said petition, Milors. The petitioner has admitted of getting irrigation to an extent of rupees 18.25 acres of land. So she has, our case is that Milors is not a fit case for exemption, but now they claim that, so that is it.
So you had given an objection, I mean, their objection, but it has been disposed of on the ground that there is no objection.
No objection. That is the Lordship directed me to produce the original records, whether in the original proceeding an objection was filed or not, Milors.
An order dated 17/1/2023. Passed by a learned single judge of this court in WPC number 18344 of 2010 is under challenge in the present intra-court appeal. First off, the appellant had challenged an order dated 30/10/2010 passed by the member board of revenue in OLR revision case number 59 of 2003, whereby
See, 1974.
970.
Yes, no.
16 of 19.
28/1974, Milors.
No, case number is 16 of
what is the
1974.
order? What was the order?
Order,
OLR case number 8/74. Yes, no.
no, proceedings had been initiated in OLR 16 of 1974.
60, right.
Whereby an order dated 24/1/1998 in OLR case number 8/1992 passed by the ADM Raigada was quashed. So this is said revision case was filed by the collector Raigada under section 59(2) of the Odisha Land Reforms Act 1960 before the Board of Revenue, Odisha. Stop. Next, while assailing the order passed by the member Board of Revenue, a specific plea was taken on behalf of the appellant that the objection filed by the appellant before the original authority on reclassification was not appreciated by whom
Thereafter, collector filed before the government.
Filed by the appellant was not. On the point of reclassification.
Classification.
The point of reclassification was not taken into account by the member board of revenue.
Member board.
By the member board of revenue. Stop. Learned single judge has recorded in the order that no objection was filed by the appellant in the original proceeding, and original proceeding, and learned counsel for the appellant failed to satisfy the court that there was any such objection filed. Stop. Next. Learned senior counsel appearing on behalf of the petitioner appellant has submitted that the learned single judge has committed an error of record by recording a finding that the appellant had failed to establish that recording a finding that there was no objection filed on behalf of the appellant before the member board of
Before the original revenue officer, that is this in the sealing procedure.
Before the revenue officer Raigada in OLR number 16/74.
10/74, I think.
16.
What is this one's name? No, 10. One is against
Saroj.
Sarojini, na?
G. Saroj.
Other two are against the other sisters.
Other two sisters.
In fact, why don't you mention that another writ application filed by one of your sisters has been allowed by the court?
That's allowed. That I have annexed the copy. Page 40, that is the annexed.
In Raigada case number 16 or 74? 16. OLR number 16/74. Stop. Next, considering the submission advanced on behalf of the petitioner, we had requested learned AGA to produce before this court the original records concerning the sealing proceeding in question. So accordingly, he has produced before the court the original records from which it transpires that an objection was filed on behalf of the appellant in said OLR number 16/74.
Within brackets, so OLR, that's right. Go to 16/74.
16/74. Stop. Next. In such view of the matter, the impugned order dated so and so passed by the learned single judge deserves interference. Stop. The said order is accordingly set aside.
In fact, one of the sisters' writ petition was allowed.
That
It is now to be decided by the honorable single judge. Now it can be remitted. Now we'll decide.
Matter will go before the learned.
Yes.
Let WPC number so and so be restored to its original file to be placed before appropriate bench according to the assignment.
Item 33.
In this case, I am a single respondent. Asked occasion, my lord condoned the delay and directed the applicant to solve a copy. I solved the copy last week. Can you allow me some time to I'll prepare my reply to the grounds. Just a second.
As requested on behalf of the.
One thing. Regarding my case, I agree. I agree to the submission by elder brother. In this case, my lord, one thing, only 1 minute I will waste lordship study.
You will waste my report.
Because your lordship is passing the order, that's why I've said it. In this case, only 1 minute by the tick of the clock. There was an advertisement. We are the diploma engineers, and we came out successful. There was a written test. There was an interview, and select list was published. They have cancelled the select list. Thereafter, we came out to the court with the hope that we'll get some relief. The judgment which has fallen from half heaven, that is almost a skyfall. That without all of our hopes and aspirations, and I am challenging this judgment on the ground that I'm mentioning it because in all the writ petitions, with the lordship's permission, I'm saying that in service matter, most probably Article 14 and 16 and along with Article 226 should have been the issue. But in this case, the case is based on the judgments which are extraneous considerations. Built on the facts.
Please, as requested on behalf of the respondent, list this matter on when? 1 week.
4 weeks time.
1 week.
2 weeks.
2 weeks.
Item 34.
34. All connected matters just now serve the copy of the IA by the appellants. So I'll take instruction, file the objection to that. I pray some tools.
IA for what?
They're seeking for direction for promotion.
During pending of the cases, my promotion has been withheld, my lord. All my juniors and batchmates have already been promoted. 2 promotions they have been given. Whereas without any fault of mine, I have filed cases only for redesignating me. But instead of giving me promotion, they have withheld without any reason, my lord. So that's why I filed this. I kindly just.
This is item number 35.
34.
34, there are so many matters.
4 matters. All 4 matters, the IA just now served to me. I'll file the response and take instruction, file response.
As it is stated by learned counsel for the respondents.
2 and 3.
That a copy of an interlocutory application has been filed. Has been served on him today.
Just now.
Today in court. So he seeks adjournment to consider this as interlocutory application. Applications or application? Separate applications.
Separate applications.
So list these applications for them. As requested, leave these matters on 2 weeks.
Item number 35.
Obliged.
If I will file a short date check, 1 week time, I am for the appellant.
Yes, you will have to come on Monday or Tuesday.
Yesterday, this one.
Yesterday matter was there. I am for the respondent 3. But it is taken 2 times, my lord.
That
The matter relating to.
mother's name was recorded.
Yes, the mother name has been recorded wrongly. That has been reflected by this.
So why didn't you prepare?
Next week, Lordship.
Tuesday, lordship, may say, or Wednesday. Tuesday.
Wednesday.
Wednesday, lord?
Yes.
Obliged.
To enable the counsel for the particular prepare a date check.
Item number 38.
Item 38.
My lord, I have given the chart. The nursing matter, my lord. Nursing matter, my lord. Subitem was has been withdrawn in the morning, first hour.
Yes.
WPC number 16725. Then the second one is 18345. Here, I will file a counter because the petition is that he has filed the requisite money But no application has been found. He has not filed the application form for renewal of the NOC. So no application is filed. Tell.
Were you not supposed to file counter affidavit for?
That's why I'm telling, I will next week I'll file.
Was it not posted to today for filing of?
No. First time it is.
First it has.
First time it is.
Okay.
Next week it should come, I'll file the counter.
My lord, mine two items, sub-item,
One at a time.
that is covered, my lord.
The third one, my lord, also the same. I have to file counter. Online application is not filed. Counter I will file.
Both. One.
Both. Yes, my lord. Then the Bharati College of Nursing 18776, it is covered by the denial for online inspection, covered by the judgment. I have given the judgment date and number.
What is that judgment?
Judgment is 16577 of 2024, disposed of on 12/8/24. 12/4/24. This is wrong. 12/4/24.
This is what principal has to appear.
No. This is the online application they denied that
Election.
Election.
Supervision. Supervision.
That inspection 3 days election we have given time. Then the my lord, the next one is I have not received the copy. I will file counter of receiving the copy. Vidya College of Medical Science.
Bharati will be disposed of 2 days.
Yes, my lord.
2
Yes,
days
my lord.
that side.
I have given the judgment, the date. Then my lord, the 19116 of 2024, this is regarding principal issue. It is covered by the judgment. Only the date has to fix, that might be 28, may be date fixed.
27.
27, because there is holidays, 28 will be better. And the next one, my lord, I will file a counter. I have received the copy. I will file the counter.
8, sub-item 8.
8, I will file counter.
In that case,
8 you will file counter.
No, my lord, I will file counter. I have got, first time it has come.
I am from the petitioner.
Just a minute.
Then, my lord, the next one is Joy Prakash, teaching experience of the 15 years of principal is not there. We will go for the.
My lord, the covered order.
Date is 28, we will fix for in principal to be present before the authority.
All right.
Principal to be present on 28th.
Yes, my lord. There are 4 to 5 cases are there. They should be all fixed to 28.
28.
Yes, my lord.
Which item?
The item is sub-item 9, my lord. My 19897.
So the principal will have to appear before the.
My lords. The next one is my lord. 20132. Last time it has come.
Yes.
Then the next one is Tejas College of Nursing, my lord. Denied of online inspection. That is covered by that judgment. So the date has been wrongly I have tried to 12/4/2024. 12/8/2024. Right, correct, it's correct. Well, that is correct. Covered with the judgment.
Yes.
The next one is also covered, my lord. The same of that I have given the order.
Yes.
The next one is, my lord, this same Joy Prakash. The principal has to appear before the authority on that date.
28.
Yes, my lord. The last one is also covered by that election.
Yes.
Yes, ma'am. That is over.
Yes. So who is appearing in item number 38.2?
Samanti.
So in this case, counter affidavit is to be filed.
Yes.
Oh, 38.2. How much time? 1 week?
1 week.
1 week time is allowed for DMET to file counter affidavit. Same order in 38.3. 38.3, who is appearing?
Also will file counter.
File counter. 38.5.
To file counter.
Counters.
A copy has to be given to me because no copy I have got. You should give a copy.
38.8. File counter, you can file that without copy.
38.4 disposal.
38.8 38.8 file counter.
Yes, smile. Register covered.
38.10.
38.10, I'm appearing for the petitioner, my lords. I'm on virtual mode. I'm
All
appearing
right.
for the.
I will file counter also in this.
You'll file counter.
Yes, ma'am.
Yes, ma'am.
Yes, so counter affidavits are over. Now item number 4, 38.4. Yes, who is appearing in 38.4?
I'm.
So it is covered by that order?
Yes, ma'am.
16577 of 2024. In terms of that order, was it? Not the way the order has been. It's not that in terms of the order. And if you have any problem, you can. Jagannath, this 28.6, 38.6.
6 and 7, my lord, is covered by your lordship, sir.
6
and 7.
My lord,
no,
this will come on
6 will come
27.
on 28.
They see these matters are coming on 27 when the applications are, they have given the deficiencies
So we'll put on
after the cut.
27th then.
Yes, 27 to be posted.
27. Why did you say 28? 27.
Yes, sir.
The 28th date, the principals will appear.
Oh, church. This 19897 of 2024, 38.9 in terms of the order in 17994 of 2024, disposed of on 6/8/2024. The date when the principal will appear, 28/8/2024. Follow करें? The date होगा principal to appear और उसमें कुछ और date होगा 28/8. These are 20188 of 2024. Who is appearing? 38.11, 16577. Who is appearing in 38.11?
In the morning hour, he was there. Now he is not there. Mr. Sohan Mishra.
He's not there, my lord.
He was there in the morning.
In the morning, he was there.
In terms of WPC 16577 of 2024. Disposed of on. Please give the orders.
Yes, my lord. I will give the order. I will give the order. I have got the order also.
38.12, 38.13, 38.14.
May I pray just 38.8, my lord? In that case, I am appearing on behalf of the petitioner. And your lordship order has substantially covered my case.
Have you served a copy of the petition on him?
Obliged.
Obliged.
I have just
not covered. I will give a counter to this
copy,
case.
my lord. A copy
I
of
will give a
your
counter.
lordship order, my lord.
I will give a counter to that.
He will file a counter affidavit.
The lordship can be picked up by the early date.
1 week.
I beg pardon, my lord. I beg pardon, my lord.
Yes.
Item number 46. There are batch of matters that work charge employees, those were directed to be, my lord, regularized in service and pension to be drawn, my lord. Those matters are, my lord, the respondents are, my lord, age-old persons, my lord. My client is around 80 years old man, my lord.
What do you want?
My lord, may be taken up, my lord, tomorrow.
Tomorrow it cannot be taken up.
I'm sorry, my lord, then next week, my lord.
Thursday.
Thursday, your lordship may say it.
Today.
It was specifically urgent.
Next Thursday or Wednesday?
46 is of which year?
22.
Let it come on Thursday, Mr. Counsel.
Thursday, your lordship may put it at 2 p.m. so that it can be taken up. my lord.
Thursday, it's very difficult. Let it be there on Thursday, because we are taking up old matters on Thursday. And this is 2022 matter. If it is not likely to be taken up, then you can make a mention at 2 or something. All right. We will try to take up your matter.
In fact, most of those matters is time barred, grossly time barred, my lord. 1100 days delay, 1050 days delay.
Which one?
That 46, my lord. I have 2 sub-items there. My lord, notice is even yet to issue in the writ appeals.
46.
36 is a state appeal.
No, similar matters we have posted together.
Yes.
Very well.
First item, there is no delay that your lordship can, if your lordship will decide this case, this will be covered by this.
No, my lord, my matter is slightly different, my lord. My matter is slightly different. And my matter is, my lord,
Day we hear it, that time that day you can make.
Uma Devi, my lord. Therefore, Uma Devi will also not apply.
Yeah, this is not Umadevi case, that work church employee, that pension, regarding that pension rule 18.
First matter, basically they have challenged that the citizens have come up after retirement of 10 years after retirement. That they have wanting to first take up that matter and cover all this matter. But we are fighting for last 20 years, my lord, for regularization.
But when the council is different, my lord, the cases are, my lord, bound to be different. My lord.
All right, we'll see. Please.